Yes.
Welcome to the Appellate Division First Department. We have over 6 hours of oral argument time requested, so I'm going to ask you to only request the time that you actually need. We have reviewed your briefs and your records and are familiar with the case. The first case is People versus Fajardo. Appellant? 4, 1, and 4. Cruz versus City of New York, and I know that there are 3 respondents. Appellant? Respondent City? Plaintiff? And Hydroforce. Okay, I'm going to give the appellant 6 and 1, the city 5, plaintiff 3, and Hydroforce 1. Hartree Partners versus Esmark, and I know there's a cross appeal on that. Appellant? 8 and 2. Respondent? I'm going to make it 6, 1, and 6. Unfortunately, we have a lot of complicated cases today, so we're going to just have to limit the time. Bashakjian versus Gateway Realty. Appellant? Respondent? 5, 2, and 5. Continental Industries versus Ustantas. Appellant? Respondent? I'm going to give you 7 and 1 and 7 and 1. Donson Nagy versus HC2 Holdings. Appellant? 5 and 2. I'm sorry, what'd you say? 5 and 2, Your Honor. Respondent? 5, 2, and 5. People versus Cruz. Appellant? 4 and 1. Respondent? 4, 1, and 4. Rodriguez versus Consolidated Edison. Plaintiff, let's do plaintiff first. 3 and 1, Your Honor. I'm sorry, 3 and 1? Yeah. I said 3, Your Honor. Okay, and I know the separate counsel Triumph. And Nico? Okay, 3 and 1, 3 and 1, 3 and 3. Rachmaninoff versus Board of Standards. Appellant? Nobody's here on Rachmaninoff? Okay, submitted. Calnet versus 141 East 88th Street. Why don't we start with DJM? Okay, and Rock? 5 and 1, Your Honor. And Philip? 4 and 1, please. And plaintiff? 5 and 2. Okay, 5 and 1, 5 and 1, 4 and 1, and 5. Maffei versus A.O. Smith Water and Arana versus A.O. Smith Water. We're going to hear both of those arguments together and just combine the arguments for the two of them. Appellant? I'm sorry, what are you asking? Respondent? Okay, I'm going to make it 7 and 1 and 7. People versus Vega is submitted. Pinpoint Multi-Strategy versus Volta India. Appellant? Request 12 and 3. Respondent? 6 and 1 and 5. Pala Assets versus Volta is submitted. Thomas Anthony Holdings versus Goodbody is submitted. Stewart versus Petrolite Incorporated is submitted. So let's call the first case, which is People versus Fajardo. Go ahead.
Good morning, Your Honors. Morgan Reed, Legal Intern, Office of the Appellate Defender, on behalf of Appellant Jasenia Fajardo. May it please the Court. Your Honors, Jasenia Fajardo deserves a very modest sentence reduction because she is a single, devoted mother who has overcome incredible adversity and showed an extraordinary capacity for rehabilitation and self-improvement. She belongs at home with her son, her family, and in her community where she will benefit others. Her continued imprisonment has no justification or benefit.
Counsel, wasn't she sentenced to the near minimum term already by the court? So didn't the court already take into account the factors that you're talking about?
Your Honor, we're here today requesting a very modest sentence reduction, and while that reduction may not seem like a significant amount, it is indeed a very significant amount of time to Ms. Fajardo and her son, from whom she has been separated for over 2 years. And while these facts were in front of the sentencing court, Your Honor need not defer to those facts simply because they were in front of the sentencing court. Rather, you may take into consideration Ms. Fajardo's continued mitigation evidence. And here it is true that Ms. Fajardo is a devoted mother to her son. Ms. Fajardo is a single mother, and her son is without a parent in her absence. She did not plan to raise her son alone, but her son's father became incarcerated shortly after he was born.
Counsel, how do we take into account the seriousness of the crime here, in terms of someone actually died from her actions, and she got a near minimum term? Why should we extend our justice jurisdiction even further to reduce it further?
It was indeed a tragedy, Your Honor, and Ms. Fajardo lives with the consequences of her actions every day. She is extremely remorseful for her actions, as she said at sentencing. The
people recommended 5 to 15, right? The maximum.
That is correct.
And the judge undercut the people and offered her the sentence that she got. In consideration of all of those factors, presumably her son existed prior to this incident, right?
That is correct, Your Honor, and we do not bring up Ms. Fajardo's son to elicit pity or empathy for Ms. Fajardo, but to simply emphasize the very real research and evidence that we wrote in our brief that shows the very real impacts that Ms. Fajardo's son will suffer as she continues to be separated from him. And further, her punishment serves no purpose. Ms. Fajardo her continued incarceration serves no purpose. Ms. Fajardo has said that she has no plans or desire to drive in the future.
How do we get to reducing her sentence in light of the waiver of right to appeal?
Your Honor, the waiver was involuntary. It was whether a waiver was involuntary is a record-based test, and the court did not place on the record the reasons it was requiring the waiver, and did so after Ms. Fajardo had allocated to her guilt on the record. The first time Ms. Fajardo heard the word waiver was after she said the words, "I'm guilty," on the record. And we find it very concerning that the court can insulate itself from appellate review after requiring a criminal defendant to give up their Fifth Amendment right against self-incrimination and then require them to give up another right.
People argue that the waiver of right to appeal was actually discussed, albeit at an off-the-record conference. What's your position?
Respondent does contend that there were conversations off the record. However, Your Honor, we have no knowledge of what that conversation entailed or whether Ms. Fajardo was even a party to those conversations. And further, she was appearing via Microsoft Teams at her plea and had no opportunity to be physically present with her attorney and discuss the waiver.
Thank you very much. You have rebuttal time.
Good afternoon, Your Honors. May it please the Court, Carl Dubel for the people. Defendant validly waived her right to appeal in this case for the reasons stated in People v. Dilworth. As far as the contention that the waiver of appeal was never discussed, that's, we believe, simply incorrect. The judge said that there were extensive plea negotiations before the plea proceeding began, and then before defendant allocated to her guilt, the court asked the parties, had a waiver of appeal been discussed? The prosecutor responded yes. Neither defendant nor her two defense counsels countered that assertion. So for those reasons, we believe that defendant did validly waive her right to appeal. Unless there's questions on that point, I'd like to move on to the excessive sentence claim.
Go ahead.
A minimum sentence in this case is entirely inappropriate. First, because of the devastating nature of defendant's crimes. Defendant ran a red light that had been red for over 6 seconds without ever having looked up from her lap. In doing this, she struck Mr. Porcari and Miss Ferrand at full speed at the other side of the intersection. Porcari was rendered unconscious and he was rendered unconscious immediately, and he was brain dead for 5 days in the hospital before his family made the excruciating decision to take him off life support.
How do you respond to your friend's point that no penological purpose would be served by her continued incarceration, given that she's a devoted mother to a young child and that she's committed to or represented that she will no longer operate a motor vehicle?
I disagree that there would be no penological purpose. First, there's retributions from the families who lost a loved one, and for the Ms. Ferrand, whose life is completely altered as a result of this crash. There's also specific and general deterrence. This sentence specifically deters Ms. Ferrand, or the defendant, from ever engaging in such reckless conduct again, but it also serves as a deterrence for others who might think it acceptable to drive distracted in the busy city streets of Manhattan. As far as the defendant's contention about being a mother, we believe that that factor was totally encapsulated in already this near minimum sentence. The sentencing court even specifically mentioned that on the record before it sentenced defendant. Unless your honors have any more questions, we ask that you affirm.
Thank you very much.
Thank you.
Your Honor, I'd like to respond to respondent's point that this court has already decided this line of cases in Dilworth. However, this case is distinguished from Dilworth because there the court emphasized the importance of making a record of why the appeal waiver was required. And again, I would emphasize that this waiver was again imputed upon Ms. Fajardo in the middle of her plea colloquy. Also, with regards to the tragic impacts of Ms. Fajardo's recklessness, we do not contend that there was no harm caused here, that Ms. Fajardo is not extremely remorseful for her reckless conduct. She is, and she is not unaffected by these actions. It's a tragedy that she is overwhelmingly remorseful for, and because of that, your honors can be confident that if her sentence is reduced and she is released from prison, she will not be a threat to others again, and she will continue to live a productive life in society and with her son. Thank you.
Thank you very much. Cruz versus City of New York.
Good afternoon, Your Honors. May it please the Court, my name is Michael Bay from Littleton Park, representing the Miller defendants. I guess without just going into the facts, since you probably already know it, I'll just tell you that, I mean, this case is identical to the McIntyre case decided by the U.S. Supreme Court. There was no jurisdiction over the manufacturer in that case, and there should be no jurisdiction over Miller here. Identically, both were British companies. They sold it to a company here in the U.S., not in New York. It ended, the company here, an independent company, ultimately sold it to an entity here in New York, and that entity placed that product on an excavator here in New York, Your Honor. Miller had nothing to do with directing this component part into New York. What happened was—
Can you describe what marketing efforts the Miller defendants did or did not take in New York or the U.S.? Well, New York.
They've done no marketing efforts, Your Honor. The one marketing item that the respondents have produced in this case is a social media post, which the case law has said is passive websites, and that would not be considered marketing. But not only that, it was actually, the one they're relying upon and the court relied upon was actually posted 6 months after this accident, Your Honor. It wasn't even before, so they couldn't give them notice, as Judge Suarez stated in his opinion. So the marketing efforts, and as I cited to the Volkswagen case in the brief, Your Honor, it's not just a post that you place on your Twitter page or Instagram page. The type of marketing that they want to see is ads, I mean, not to the extent maybe as Ford Motor Company, where they bombard everything, but there's nothing in the record that shows any marketing efforts by Miller into New York other than an Instagram post while the owner of the company was going through the airport, and took a picture of an excavator with a coupler on the machine, Your Honor. In McIntyre, it was again a manufacturer who there sold it to an exclusive distributor. And I know respondents have cited to two cases, Kappas and Kernan, related to exclusive distributors and how those courts have found that there was personal jurisdiction. There was no exclusive distributorship agreement here, Your Honor. Miller sold it to an unrelated third party named ESCO. They negotiated the sale in Oregon. They shipped the part to Mississippi. They had no other contacts with this product. And because they didn't know where it was going, that was all up to ESCO, Your Honors.
Counsel, was there any weight to the argument of the patent lawyers that were sought by the Miller Company in New York?
At least the cases that the plaintiffs or the respondents cite to, it is a case where the claim itself was directly involving those lawyers, right? Someone didn't pay the bill, and they sued them, and so that's why there's jurisdiction. There was at least a nexus or a substantial connection to that case. In this case, the evidence states that Miller hired lawyers in the UK to file patents. They filed patents in the UK, and they hired lawyers in New York, the law firm did in the UK, to help with the filing of the patents. But none of those have any nexus to this lawsuit. It's kind of akin to Bristol-Myers Squibb, right? I mean, they made $900 million selling Plavix in California. They had over 400 employees in California. They had 5 offices. They had a lobbying group there. Despite that, because the claims were not connected to the use of Plavix in that state, the court held there's no personal jurisdiction.
Counsel, is there any relationship whatsoever between the litigation that your clients engaged in another part of the country and this lawsuit in New York?
None, Your Honor. I mean, that's an Illinois case. The respondents keep citing to contacts with the U.S., but the U.S. Supreme Court has held over and over again that that's not the contacts we should be looking for. We should be looking for form-specific contacts, and there aren't any here, Your Honors. If there's no other questions about it.
Thank you very much.
Thank you.
May it please the court, Brendan Fitzpatrick, counsel for the respondents, of the city and Delta. Your Honors, I think at the very least, there is a question of fact, as this motion was made before discovery.
What question of fact? What's in dispute?
What's in dispute is what sales and what activities Miller actually engaged in.
I don't know. You have to have something to start out with, right? You
Yes.
can't just say. So what do you even have to start out with in that regard?
We have a tortious conduct outside of New York that caused injury to a New York resident within New York. Those are the first 3 requirements for CPLR 302. Then we have
Is that enough by itself, or there's another
no.
prong
There
to that
is
test?
more. We
How do
have
you satisfy the other prong of the test?
because Your Honor, we have a non-resident tortfeasor that should expect to be hauled into court.
But I mean, that is exactly Bristol-Myers Squibb, right? Every multinational corporation, that is, as we know, not sufficient.
In Lamarca,
So then what are you talking about in New York?
there can be a single transaction that is sufficient.
And what's the transaction?
Not under that you can't just mix, you can't just mush all 3 302 sections together. You're talking about tort outside of New York that injury occurred in New York, right?
Yes.
That's not the same section that you're talking about, the 301A1, 302A1, correct?
No, we're 302B2.
I'm sorry, 302B2. So what are you saying in B2? Where's your first start? Where's the connection to New York?
Where's the connection to this incident?
Yeah.
We have a UK Miller coupler that
Now,
causes
what's
injury.
happening in New York? Other than the injury, what has this party done to insert itself in New York? Not in the United States, not in international commerce, because as we all know, between Daimler and today, that's never going to be enough.
Well, 302A2 does support international commerce, which we have here. And Miller has admitted freely that they make tens of millions worldwide.
Counsel,
including-
that's clearly not
Your Honor?
enough under the law. You have to show transactions of business in New York, a connection to New York, other than the fact, I mean, the law is black letter law. Just putting a product into the stream of commerce by itself is not enough, and that's all you seem to be arguing. You have to show, in addition to that, the connection to New York.
Mr. Parkin and Mr. Miller admitted in their affidavits that they don't derive substantial revenue. They do derive revenue from New York, and they do conduct business. They just said, we don't conduct substantial business. We have no idea what that actually means, but we do know that they hired New York attorneys to prosecute their patents. Now, they can claim they...
What does a patent litigation have to do, though,
patent
with this lawsuit? What relationship, if any, is there between that litigation and this
Patent
lawsuit?
litigation dealt with the couplers involved in this accident. So there is at least a sufficient...
No, wait. What you're saying is they hired New York lawyers, which you have to do, right? British lawyers can't file New York patents in New York. So you have to hire a New York lawyer. And you're saying that the patent has something to do with this litigation?
The patent for the coupler was one of the patent prosecutions that was involved.
No, I'm saying, so how does the patent have to do with the fact that your client got injured?
My client didn't get injured. My client
I'm
is...
sorry, the plaintiff got injured,
Plaintiff.
right?
We're trying to hold Miller...
I'm asking you real straight. How does the patent have to do with the plaintiff getting injured?
The patent application provides a sufficient nexus to New York. They conducted...
Simply because someone filed the patent here? So every patent you're saying that is filed in New York would be a basis for jurisdiction?
They didn't have to hire New York attorneys. They could have hired attorneys from D.C. with the patent law offices, but they did hire New York lawyers.
I'm just asking you if you think that any time someone files a patent here in New York, that confers jurisdiction on New York.
I think
that's what you're saying.
I think at this stage of the litigation, where we have not been able to obtain any jurisdictional discovery, I think at the very least it should open the door for us to engage in some kind of jurisdictional discovery where there had to have been numerous conversations between Miller and New York for the prosecution of the...
Thank you very much.
May it please the court, Michael Zhu of counsel to Pollock, Isaac, and DeSico, appellate counsel to Kork, Leibowitz, and the issue with respect to the patent. I believe there's evidence in the appendix that talks about the patents that were in litigation in Illinois deal with the couplers that were involved.
And that's in Illinois. Again, we all know you can't just generally say you're here in the United States. I keep trying to ask, what is it connected to New York? The fact that you file, I don't think anyone would say as a straightforward matter, the fact that you file a patent in New York means that you're subject to New York jurisdiction for any claim that arises out of your product. I just don't think that that's the law.
No.
So then you're talking about litigation that occurred in Illinois. I'm trying to figure out, other than the fact that this company has a big presence in the world and makes couplers, what connects it to New York specifically? Because we all agree, no general jurisdiction.
If we could trace the coupler from UK with the signing of a distributor agreement in Oregon that was shipped to Mississippi, and from Mississippi to a distributor in New York, that has presence, that has 2 offices in New York, one in Rochester.
Is that
one in
distributor
Holbrook.
hired by Miller?
I'm sorry?
Is that distributor hired by Miller? I
No.
mean,
No, it
right,
was not.
Right?
But there's
No
this stream.
contractual, no, but that's the stream of commerce, sort of. I put it in the stream of commerce. That is not enough. Or at least that's what the Supreme Court has said, right?
Well, no, actually, in Ford, the Ford Motor Company manufactures the vehicle outside of Montana and outside of Minnesota.
But in that particular case, there were several other advertising efforts that Ford undertook, right? They were specifically saying buy Ford vehicles, even in the resale
But
of
we're talking
those,
about two different things then. One is the marketing efforts by Ford, and the other is the sale of the vehicle through distributors and third-party used vehicle dealerships. So these vehicles wind up in Montana and wind up in Minnesota, not through the efforts of Ford Motor Company, but the Supreme Court, Judge Kagan, held that this
No, but that was one of several factors, as my colleague said.
Sure.
We don't have that here. We simply do not have it.
Well,
We don't have any marketing here in New York. There's plenty of market, and Judge Kagan, Justice Kagan,
yeah, Justice Kagan, yes.
specifically noticed that, and even all the concurring opinions talk specifically about that.
But the
issue,
question,
right?
but the
That it was
question
a-
posed
It
was,
was a
but
number of issues there, a number of factors there.
well, the question
We
posed,
don't have here.
the question posed to me was what's the connection and how do we get that coupler between Miller and New York State? And I just provided an example of how that happens.
Thank you.
So it doesn't matter that Miller didn't sell this product directly to the end user in New York.
Thank you
fact
very
that it
much,
found it-
counsel. Thank you.
Sorry. Thank you.
Good afternoon, Your Honors. I will rely on my colleagues' arguments and will defer to the appellant for his closing remarks. Thank you.
So, counsel, what do you say to that? Is it enough to just say somewhere down the line it ends up in New York, that Miller sells it to someone who markets it to someone who sells it to someone, and somewhere down the line it ends up in New York?
Absolutely not, Your Honor. In fact, in Worldwide Volkswagen, they addressed that very issue because they said that if the rule were otherwise, the law would be wherever a product ends up would permit jurisdiction. So really, it would be the chattel itself that would confer jurisdiction. And the courts have said that is not what we're going to look
But
at.
sir, we seem to be talking a lot about the due process points. If we find that there is no jurisdiction under one of the statutory predicates under 302, we wouldn't have to get to the due process inquiry, would we?
No, we wouldn't. And that's, I mean, first of all, there is no allegation, there's nothing pled about a transaction of business. The only thing that they may have pled in that third-party complaint was 302A21. No transaction of business.
Thank you very much. Hartree Partners versus Esmark Steel.
I may just,
Go ahead. I won't even count it against your time.
that's why I only put a quarter of a cup, Your Honor. Okay, and I'm pushing this way over on the side so nobody touches it. Okay. May it please the Court, Your Honor. My name is Melvin Brosterman from Strucken Levan, representing the appellants and the plaintiff in this case, Hartree. Let me start with the repudiation. This is an unusual motion to be on appeal on because we filed a motion for summary judgment and there was no evidence in opposition. Literally, not a stick of evidence in opposition to the motion. Okay. On the subject of repudiation, there were three contracts for the sale of steel. The contracts call for delivery at different points in time, but the contracts are entered into between July and September 2019.
I'm sorry, I'm surprised we're starting with repudiation, but if we are starting with repudiation, why isn't there an issue of fact based on the opposing side's position that they said, they didn't deny that they said that they wouldn't take his offer or at a reduced price or leave it. They say that's not how the exchange took place, that they were always still willing to purchase it, but they were just entering into negotiation. Why doesn't that raise an issue?
Okay, because here's the admissions. Ready? Okay. Record 278. This is reflected in a text exchange between two individuals within Hartree after the first call from Mr. Ogrizovich, who was the president, repudiating. He says, so the text says, Ogrizovich called to say that his boss, Bouchard, won't, it says, let him pay Hartree more than $40. Okay, next one, February 13, there's an internal email which Mr. Ogrizovich at his deposition admits is a fair characterization of his call. Fair characterization in which Mr. Weinstein says internally, he's reporting on the call, he said, I asked Mr. Weinstein, I asked him, that's Ogrizovich, if his boss knows that our contract was not an option for good time only. He didn't disagree, but said, I have been instructed not to show more of a loss, and this is the best we can do. He admits that he said that, okay? On February 13th, again, there's an email from Mr. Weinstein to Mr. Ogrizovich saying, okay, the fact that the market has gone down is no basis for your having insisted that you will not accept and pay for this deal. Okay, the end of that email says, if S-Mark is prepared to proceed in accordance with our contracts, please let me know immediately and we will make arrangements for the deliveries. No response. Mr. Ogrizovich, affidavit, admits he never responded. Admits he got him, never responded. Next email, February 15, which Mr. Ogrizovich also agrees he got, but said, I didn't feel a need to respond. I never received a response to my email below. That's the February 13. In light of S-Mark's repudiation of our contracts, we will be selling the metal to others at prevailing market
How does
prices.
this tie into that there's still potentially a factual dispute as to what actually the terms of the agreement were?
I'll get there.
And whether, I know, but how does the repudiation issue tie into that issue?
Okay.
If the parties never agreed as to exactly what the terms were that they had to accept it on, how could they have repudiated it?
Okay. Actually,
You were saying accept it on the terms that I believe are the terms.
okay, because there's no evidence in opposition to that either. Here's the evidence, Your Honor. One-sided, nothing against it. Mr. Weinstein testifies in his affidavit, and there's no affidavit, deposition, anything in opposition, that he had done business with, he had been at a prior firm, had done business with this company, S-Mark, for years, and that everything was negotiated through the same process, consummated through the written sales contracts, and effectuated through the same course of dealings. This is from our numerous courses of dealings. Mr. McKenna, who was the individual with whom he negotiated after Mr. Ogrizovich, and I developed a regular practice whereby once all the terms were finalized, I memorialized them in a contract of sale.
Counsel, I understand that's your argument, but their argument is that the purchase offer is what is the initial binding agreement, and there are things that support their argument, including that there was no quantity listed when you initially sent out your first price quote.
The problem with that statement, Your Honor, which they say is, okay, the attorney attaches purchase orders. Mr. Weinstein says, okay, that our practice, and I told them, and they agree, says it 3 times in the record, is that the purchase orders routinely contained errors. I also told them after I got a purchase order, we would have to check with Emil. We would negotiate, correct the terms, and that the only documents that contained all of the terms in the contract, okay, were the sales contracts or confirmations. And what they say, what Your Honor has just repeated, what they say, you're right, they say that. But you know where they say that, Judge? They say it in their brief without a single citation. So they say in their brief, these confirmations didn't manifest in acceptance of the terms. The lawyers say that. There's no record in the evidence. They merely constituted proposed modifications. The lawyers say that. Not a single citation.
Can't we only determine what's the offer? I mean, it sounds like a contract law school exam, but can't we only decide what's the offer and what's the acceptance by deciding whether those purchase offers, what they constituted, were they an offer or were they an acceptance? And how do we know that on this record?
Okay, it's really simple, Judge. You know it because They have to put in some evidence. A lawyer can't put in a document and say, and then make an argument. What, in contrast, you have uncontradicted affidavits and deposition testimony, uncontradicted.
But why aren't the documents themselves the best evidence of what the agreement was, what the purchase offer
Because-
says, what the price quote says, and what the confirmation says?
Because the purchase orders do not say, okay, nobody has taken the stand to say, the purchase orders, the lawyer has said it, nobody has taken the stand like Mr. Weinstein does in his affidavit to say, the purchase orders set forth all of our agreements. To the
Okay,
contrary.
you'll have rebuttal time.
Okay.
Thank you. You'll have rebuttal time.
Thank you, Your Honor.
May it please the court. My name is Jerry Stubenhofer, and I and my colleagues at McGuire Woods represent S-Mark Steel Group in this matter. Your Honor, you're exactly right. There is a genuine issue of material fact as to whether there was a repudiation in this case, and the evidence for that genuine issue of material fact comes
I
from...
wasn't saying one party was right or wrong. I was just asking questions.
I understand. I don't mean to
have a position
mischaracterize
yet.
the question, but it perked my attention to hear that the genuine issue of material fact, because there is indeed one as to whether or not there was repudiation in this case. And the evidence for that perhaps best comes from the witness who allegedly repudiated himself, Mr. Ogryzowicz, in his testimony. When he testified in response to this question, to be clear, you told Mr. Weinstein that you were not going to accept the goods at the contract price you wanted, and you wanted a reduction to $800 per ton, correct? What I said is, this is his answer, I was looking to my vendor, the plaintiff, Hartree, who did not meet the required shipment in a market that was moving south to work with us, and that we would find a way to make them, Hartree, whole. I don't recall saying take it or leave it, if that's kind of what you're implying. I don't recall that. He didn't tell him take it or leave it. What he did is he went to him after the market price had precipitously dropped from the date that the contracts were formed to see if they could negotiate a better deal on the price. And perhaps the best evidence of what was communicated in that transaction between those two gentlemen is the conduct in which Hartree engaged immediately following. They did not put their hands up and say repudiation, I don't have to perform. What they did was they began to renegotiate. They suggested to Mr. Ogryzowicz that before they would consider any pricing negotiations, they would have to have an adjustment on the payment terms. They said you would either have to prepay or get a standby letter of credit. When a party repudiates an agreement and says they're not going to perform, the reaction of the party receiving that repudiation is not to engage in negotiation. If he made the unequivocal statement...
You move for summary judgment on...
I move for summary judgment on the question of a partial summary judgment on which contracts control.
Right, and whether the terms and conditions are actually controlling or not, because that impacts the issue of what is or is not a repudiation. They're intertwined to some degree.
Well, a repudiation is more governed, Your Honor, by the case law in the UCC governing it that requires an unequivocal statement of a willingness to not perform or a cessation of performance.
But part of it is whether the credit terms that are incorporated in the terms and condition are part of the contract that you were required to comply, or are they not part of the contract that you had no obligation to comply?
Indeed. That is, if you accept the fact that the confirmations that were sent after a contract had already been formed somehow already altered a pre-existing agreement that had been met with offer, which came in the terms of the email, acceptance, which came in the purchase order, what was contained in those confirmations?
Let me ask you the same question I asked opposing counsel. How do we know whether the price quote was an offer or whether the purchase order was the offer? How
Oh,
do
you
we
know by
decide that
examining...
as a matter of law?
Certainly, you know that by examining the emails themselves that went out. First, the emails that Hartree sent out were self-styled offers. They were offered to sell cold roll steel. We offered to give you this steel. And they contained sufficient information to constitute an offer. They identified the product that was for sale. They identified the material grade. They identified the size, and they identified the tolerance levels. They identified the quantity of what was available. In one instance, they specifically said we have one barge available for sale. They identified the price of the product. They identified payment terms, and they identified shipping information. And importantly, they also contained an expiration date of when the offer would no longer be valid. That is sufficient to constitute an offer pursuant to the case law that's contained in our brief. In this case, what followed was the issuance of a purchase order.
And why isn't the price quote an offer?
The price quote is what I'm talking about. The email is the offer. The email.
I thought you're saying that the purchase order is...
No, the purchase order is the acceptance. The email that they sent out that they call the
Okay, then
offer
why
is the
is the
offer.
price quote an offer where it doesn't list a quantity?
Well, it does indeed identify quantity. It identifies the quantity that is, at the very least, available for sale at a certain price. So it tells you what is there. And in one instance, it does identify specifically that there is a barge for sale that they can purchase if they wish. And those are contained in the email offers that were issued. And the acceptance of those offers comes in the form of the purchase order, which answered what they wanted, and again, set forth the price, and importantly, set forth a shipment date that was not honored, which was the required date listed in each of the purchase orders that was violated in this instance by late.
Well, sir, what do you say to your friend's point that there was a course of dealings between these parties that informs this issue, and that is that there would, in the face of the offer, the email offer, or however else it was transmitted, there would follow formal contracts?
That is not correct. There is a course of dealing that establishes exactly the scenario that we have posited warrants summary judgment in our favor. The course of dealing is the issuance of solicitations that contain sufficient information to constitute an offer, and then the issuance of a purchase order, which was the acceptance of that offer. These gentlemen had engaged in that course of conduct previously while Mr. Weinstein was with a different company that merged and became Hartree, and that went back on for years. The reality is, the problem with one of the underlying problems with the theory here is that in order to form a contract, you don't need a letter saying, oh, by the way, we have a contract, and it puts a pin in it, because this just makes sure that everyone understands we have a contract. Under the UCC, when you're dealing with merchants as you're dealing with here, you have an offer in the form of the email, the acceptance is the purchase order, bang, that's the contract. Those are the terms. They cannot be altered by subsequent iterations of a deal that were never made or never considered prior to the formation of the contract. That evidence does not constitute an alteration of the contract's terms.
Thank you. You have time for rebuttal.
Thank you. Actually, I don't believe I do, but.
Don't you have a cross appeal?
I'm sorry?
You have a cross appeal. Do you not want rebuttal time?
I'll take it if I've got it, yes. Thank you.
No, I gave him one. Yeah, no, I did, because you do have a cross appeal, so you get your one.
Okay, everything you heard from from counsel came from counsel. Nothing is in the record, okay? They say it's the purchase order and the contracts. Nobody really relied on them. Nobody took them. It wasn't part of the dealings between the parties. Nonsense. Ready? Okay, in addition to Mr. Weinstein's multiple statements that the only document that had all of the terms, and this is the way we dealt for years, was the contract, also called confirmations. There's, in the record SR 130.
Counsel, was there any other instance of actually invoking the terms and conditions in the relationship between the parties?
The contract's always governed, Judge.
I'm asking you whether, you're saying there was, yes, we have this course of dealing. We always invoke the terms and conditions.
Yeah.
That's what I'm asking you. Is there any instance specifically where those terms and conditions, which are now the dispute here, were actually invoked in a
Sure. They routinely shipped basically within the time frames of the contract.
Was there ever a situation where the terms and conditions became an issue between the party?
Never.
So there was never a situation where one party before this said, yes, these terms and conditions apply, and the other party said no.
No, and what you have is, okay, they say the shipment was late. Routinely, there's evidence in the record from both their witness and my witness that says routinely the products arrived well after the so-called required date. In addition, to the point that they say, well, you know, these contracts don't mean anything, they don't constitute anything, the deal was already done. There is a record SR 131. All three of these contracts, after the deal is done, there's an email which says, we'll send you our contract shortly, for example.
I'm sorry, Counsel, you're going beyond the question, and your time is up. So.
SR 131.
Counsel, you're going beyond the question she asked, though, and your time is over.
But I never got a chance to say one thing. On SR 131, Your Honor.
Counsel, your time is up. Thank you very much.
Okay, because Mr. Ogrizovich got these. I refer
No, I was going to let you answer the question, even though your time was up, but you went beyond what the question was being asked.
Refer the court to SR 131.
Thank you. Go ahead.
Thank you, Your Honor. To my knowledge, to answer the question, there's never been a situation, certainly not part of the record in this case, where in the history of the dealings between the parties, the terms and conditions contained in the superfluous confirmations that were sent ever were invoked to govern the parties' relationship. The parties' relationship historically was governed by exactly what constituted the contract in this case, namely the emailed offers and the purchase orders that followed that were the acceptances. So there is no evidence of a history of dealing that would lend any credence whatsoever to the theory that the after-the-fact self-styled contracts were indeed anything other than superfluous communications sent over a month after the contract had been formed. With respect to the evidence issue, the documents in this case tell the story. You can tell what the purchase order says because if you read it. It contains its terms. You read the purchase order, you can see what it says. The purchase order is properly in front of the court, as are the other documents proffered through the attorney affirmation, because she's not offering any evidence or conclusory, unsupported statements without a knowledge of what's going on in the facts of the case. She's merely using it as the vehicle to proffer documents, which this court and other sister courts have repeatedly held is a proper use of an affirmation to get evidence in.
Thank you very much.
Thank you.
Okay, I apologize in advance for mispronouncing the next case, which is Bashaktin versus Gateway Realty, and Justice Rodriguez is disqualified.
Good afternoon, Your Honors, and may it please the Court. My name is Lauren Bryant, and I represent the appellant, Ms. Bajakchan, in this case. We respectfully ask that this Court reverse the lower court's award of summary judgment to the city and reinstate the complaint because the Court critically erred in failing to consider that the plaintiff overcame the failure to plead prior written notice with evidence of the 2003 Big Apple map, which depicted the defect that the plaintiff complained of in this case. The city does not contest that it owed a duty to maintain that portion of the sidewalk, which was within that 12-inch diameter of the manhole. The only thing that the city contests here is whether or not the legend on the Big Apple map has a symbol
How
that's...
does the description on the Big Apple map match up with the alleged defect claimed by the plaintiff?
So, Your Honors, if you look on page 1164, 1163 is the blown-up version of the Big Apple map, and 1164 is the legend. There's a circle with a vertical line through it that's deficiencies pertaining to metal doors and frames. And we submit that that applies to the manhole in this case, particularly because if you look at our expert's affidavit on page 1153, and the photograph that the plaintiff identified on page, I believe it was 726, we can see that the broken cement creates a hole, a hazardous depression in the perimeter of that manhole, and that's the defect that caused the plaintiff's injury in this case. At bottom, Your Honors, the plaintiff need only raise a triable issue of fact in this regard.
What about the argument that that description does not really adequately describe what the defect was, which was a depression in the road as opposed to a crack?
So 2 points to that, Your Honor. One, we contend that it is at minimum a triable issue of fact, and as this court has held time and again, particularly I point, Your Honors, to the Patterson case from 2003. If the plaintiff can identify the correct location of the fall and a defect there, where there's an issue of fact as to whether the defect in question corresponds with the symbol that's at that location, and I think there's no denying if we look at the map that the symbol in question is exactly where the plaintiff fell next to this manhole cover or on this manhole cover, that at bottom that's a triable issue of fact. But the second part to that, Your Honors, is if we take those symbols also and view them another way, we can see that one, a vertical line depicts a raised or uneven sidewalk, and a circle is a hole or a depression. And when we look at the plaintiff's testimony, when we look at the photograph of the defect, we can see that that's exactly the defect that the plaintiff tripped on. So either it's the circle with a line through it showing that there's a defect pertaining to metal doors and frames, which there was in this case. There's a hole butting up to the manhole cover, or we can look at those symbols separately as they're in the same place as a raised uneven sidewalk and or a hole or depression. construction.
What about, I'm going to switch topics for a moment. What about the claim by the city that since the Big Apple map was created, there's been further repairs done to that sidewalk, and the sidewalk was no longer in that condition at the time of the accident?
That claim is completely speculative, Your Honor. It's based on a 2011 Google image, which respectfully does not zoom in to the manhole. You really can't see anything from those pictures. And in any event, we submitted 2013 Google images, so closer to the time of the accident, which actually shows an uneven sidewalk condition abutting that manhole cover, and it's actually a closer image. That is, I believe, on page 1136 of the record. And I would just like to point out two more things, Your Honor. I see my time is running out. One, on page 12 of their brief, critically, the city concedes that it is not clear whether or not the defect in the symbol, on the defect symbol on the Big Apple map corresponds to a manhole cover. So the city is effectively conceding a triable issue of fact in this regard. And two, I think it's important to note that D'Onofrio is completely distinguishable. Your Honors, look at the city's brief in that case on page 5. The Big Apple map witness in that case said there was no corresponding symbol for the cracked, uneven sidewalk in the location of the plaintiff's accident. We don't have anything like that here. We have a reasonable interpretation of the map, which corresponds in the exact location to the defect complained of by the plaintiff. Thank you.
Thank you very much.
Good afternoon. Eva Jerome from the New York City Law Department on behalf of the city. There are two independent reasons this court can affirm the dismissal. The first, of course, is that they failed to plead prior written notice. Under Katz and Kales, this court can decide.
And so why shouldn't they be allowed, though, to amend the pleadings to reflect the Big Apple map, which was produced by the city? What's wrong with amending the pleadings to allege that?
Even if you were to consider the Big Apple map, there is no symbol for the defect complained about. They've now had a sequence of 4 iterations, 4 different theories, and I'd like to walk through them. The plaintiff complains of a depression and a hole that's 2 inches deep, and her expert uses the term cavity and relies on a soul
Why
symbol.
wouldn't that be covered by cracked sidewalk? Or at least raise an issue of fact as to whether cracked sidewalk is sufficient to be describing that defect, since it is in the location where she's saying the cavity was.
But the expert swears that the symbol that's there with a circle with a line through it, which means deficiencies pertaining to metal doors and frames, is the symbol that matters, and that's
why isn't there an issue of fact? And if you want to focus on that, deficiencies pertaining to metal doors and frames, why isn't there an issue of fact as to whether that refers to a manhole, which a manhole could be described in that fashion?
Because the Big Apple map, if it wanted to say manhole, would have said manhole. There simply is not a symbol for manhole, and in fact,
There is a symbol for manhole, or there is
no,
not?
there's not. I'm sorry if I misspoke. There's not.
So if there's not a symbol for manhole that's normally used, what is wrong with using, or at least creating an issue of fact based on using deficiencies pertaining to metal doors and frames?
Because she said that her injury was caused by a hole in the sidewalk, and there's no...
Right, she said a hole in the sidewalk abutting the metal frame, right?
Right.
So if you want to, I think that's the whole point, right? What you're asking us to do is parse it to such a fine point where what the plaintiff testified to, what the pictures show, and what the Big Apple map show, all could be considered, using it in a more not so fine way, to be depicting what the plaintiff fell in, correct? Or not correct?
Not correct, Your Honor.
Well, what do you think? What do you think the plaintiff said? I fell in that little piece right next to the metal, the manhole cover. Right. The Big Apple map says there's a problem with metal, and you know, we can look at the picture. There's no door there. That's the only metal there, and the big crack next to it is shown. So why is that not sufficient notice?
Because there's a symbol that's separate for cracked sidewalk and a symbol that's separate for a depression or a hole, and the symbol for hole is not there. And I need to point out that even as plaintiff herself indicates, she's actually contradicting herself now by relying on Hennessy Diaz, in which there was a witness from the Big Apple map who said that the manhole covers are represented by yet a fourth symbol that she's referring to. So if she's switching from her expert to something that her lawyer says, saying it's the zigzag line, to now saying there's an inexorable conclusion that deficiencies pertaining to metal must relate to manholes, but then she cites Hennessy Diaz saying, but as a matter of fact, this court has seen a witness from BAM say it's in uneven sidewalks. That's where manholes are covered. And she's doing a hybrid approach, and now she's doing a deconstructive approach by saying the fact that you can take the line out of the circle. She literally said, you can take the line out of the circle, and there you, lo and behold, you have the circle. That is the only symbol that reflects the complaint about which she complains. There's no support for being able to imagine the line removed from the legend. That's just making that up. So the symbol that represents what she's complaining about simply isn't there, and that can be established as a matter of law by this court. And in any event, the Big Apple map was from 2003, and the photographs that post-date that show that repairs were done. Whether there was a crack then between 11 and 13, that means the Big Apple map couldn't have provided prior written notice.
Thank you very much.
Thank you.
Just briefly on rebuttal, Your Honors, it's not as though the plaintiff is changing up her testimony or changing up the characterization of the defect. I think, in fact, pointing to perhaps some ambiguities in the Big Apple map shows the triable issues of fact in this case, shows that there are potentially a few different interpretations here. However, all of the interpretations that we have pointed out line up directly with the defect complained of by the plaintiff, and not just through her testimony, but the defect that is clearly shown in the photo on page 726. That depression, that uneven broken cement, that defect butting up to, as our expert noted on 1153, the metal frame of the manhole cover correspond altogether with the circle with the vertical line through it. The vertical line.
Counsel, what do you say to the city's argument that that map couldn't have given notice to the city because the city has shown that they repaired that prior to plaintiff's accident? And your statement before, well, I have other photos, but that doesn't, you'd have to show another Apple map, right? Which you haven't put in, have you?
Certainly, Your Honor.
How do you deal with that?
I was addressing that very briefly, and I'll get more into that as brief as I can, which is that the photos that the city has annexed, first of all, that's purely speculative. The city hasn't given us any evidence that any repairs were performed to this area. And if you look at the photos that they provided, those are on pages 1148 and 1348 and 1349. We can hardly see that whether a defect exists there or not. Those photos are way zoomed out. It's not possible to tell. I was simply providing that if you look at our photo from 2013, which is a bit closer up, you actually can still interpret that as seeing the defect. And so without any evidence from the city that repairs were actually performed and relying on a Google image photo, which is completely zoomed out and taken out of context, that is not enough to show that the repairs were made to the defect in this case, particularly when you have the other photograph on 726. Thank you.
Our next case is Continental Industries versus Unstantas.
Good afternoon, Your Honors. I'd like to start with the breach of fiduciary duty claim, if I may. It's here based solely on conduct that's alleged to have occurred after the termination of the alleged employment. As Your Honors know, we don't concede that Mr. Ustuntaş was ever an employee of CIG, let alone of fiduciary. But even assuming that he was any such employment, it's undisputed that such employment ended in March of 2008.
Part of the allegation as to breach of fiduciary duty that he deleted emails from plaintiff's server after forwarding them to his address. Didn't that happen during the time of his alleged employment? Assuming there is employment, there's basically two different claims, and one did occur after his employment, but one occurred during his employment.
Right,
What's
Your
your
Honor.
response to that?
And that was going to be my next point. This evidence that he deleted emails, there is no such evidence. There's a claim that he was taking information, stealing information from CIG's server in New York, and then somehow forwarding himself that information and then deleting those emails. But there is no such evidence of this because there's a record of spoliation below, and plaintiff admits it has no evidence.
Wasn't there some affidavit from the technology manager indicating that he told Mr. Usantas not to delete the emails once he discovered this was going on?
It's the IT manager. It was in the context of a spoliation application, Your Honor, and in that affidavit, it's actually Ms. Eviopan, who is the wife of the respondent's principal. She doesn't claim that she knows what's in those emails. She just says at some point he was deleting emails and he was forwarding to his personal account emails. And the record shows clearly that there were he was experiencing technical problems. All of his CKS colleagues and principal of CIG, Mr. Karabey, knew about it, and they themselves were using his email addresses that's during that period. They don't have evidence of it, and if we read the affidavits closely, they don't claim to know what's in these alleged emails. But they do produce one email, and that doesn't come from CIG's server, which has been the allegation all along, that he was actually physically stealing things from their server in New York. It is an email that he forwarded to his personal account at a time during a period when it's undisputed he was using his email for work purposes, and they knew about that. And they actually say, quote unquote, "This is not evidence of diversion of confidential information or trade secrets, so much as evidence as how he would improperly divert such information." They don't have this evidence. They don't dispute that they don't have that evidence, and it's not going to change at trial. It doesn't present.
I'm going to interrupt to ask you a question about one of the specific causes of action. And what I'd like you to address is the statute of limitations on the misappropriation of confidential information and why you believe that the statute of limitations has run on that claim.
Yes, Your Honor. The misappropriation, the statute of limitations would have started running at the misappropriation. It's alleged that such misappropriation started occurring in 2004. It's the plaintiff's burden to show some kind of an exception to that. And what they've alleged is that they did not know about it and there was some effort to conceal this, which is not the case at all, but let's go with that. At that point, the case law is clear. The Synergetics case and all of the cases cited in it, the case law is clear that when they're aware that a defendant is allegedly using this information, that's when that defense is no longer available. We have an email on the record in June of 2009 where Mr. Ustuntaş apparently asked a supplier that plaintiff considers its supplier, and plaintiff's principal has testified that that was considered a misappropriation because they're claiming that the mere identity of that supplier is a trade secret that belongs to them. June 2009 was when this email happened. In fact, plaintiff's principal tried to interfere with such business and said, "Oh, we knew about this company. They're a small-time company." and we would really hope you wouldn't do business with them. 3.5 years later is when they filed the complaint, which is untimely as respects to that, misappropriation claims and unfair competition claims. And again, the breach of fiduciary claim, we've addressed at length. There are no equitable claims left here, and any equitable relief that is there is incidental. The case law in this department is clear that, let's say, for example, you have an accounting that's merely there to, not an equitable accounting, but merely there to assess the amount of
What about the
damages.
allegations of fraud in terms of the 6-year versus 3-year statute of limitations? Aren't there allegations that there was fraudulent conduct on the part of the...
So there is no fraud alleged or pleaded. There is, like, the word fraud appears once in the complaint. As your honors know, it has to be pleaded with particularity. And it's clear that this is not something that's by definition fraud. There has to be an underlying fraud alleged. It's not been alleged, it's not been proven, and there's not been any evidence assessed, produced with respect to that, and it's not in the record. So,
Sorry.
sure.
I heard an echo from down there. Walk me through your prima facie showing on the plaintiff's cause of action for tortious interference with prospective economic advantage.
So, Your Honors, I'm glad you asked that question, because we made a very detailed showing on tortious interference claims. And basically what we've shown is there was just this ever-changing list of companies that plaintiff has alleged has been interference with. Now, our burden on this was simply to show that of all the facts out there, with everything that they've alleged so far in these past 10 years, they can't put them together to create a triable issue. And we've shown that by saying that they have shown no interference, they cannot show but-for interference, and in fact, we may have done business with a fraction of those companies, and there is no causal connection between those.
Thank you very much. You have time for rebuttal.
Thank you, Your Honor.
Michael Conway, Lazari Parajikos, and Kranjak for Continental Industries Group, Inc.
Counsel, I want to ask you the same specific question that I asked opposing counsel, which is to comment on the statute of limitations for misappropriation of confidential and proprietary business information. How are you claiming that you've satisfied the statute of limitations, or at least raised an issue of fact as to whether or not you've satisfied it?
Well, we believe that it's pretty clear that all allegations are in the context of fraudulent activity. In fact, it goes beyond just what we believe. We've alleged that it's all in the nature of fraudulent.
Right, but now we're on summary judgment, right? We're not on your allegations. So what are you, in opposition, when are you claiming, and when will you claim at trial that your damages began?
The damages for misappropriation, well, we know that they were occurring as of 27, 28, 29. They're continuing after we file this lawsuit because we've got...
Well, Counsel, in June of 2009, that's when plaintiff would have become aware of him contacting the Mexican company. I don't know if I'm pronouncing that correctly. What after that date, after June 30th, 2009, would go to your claim for their misappropriation?
We have, I can give you the site, but we have contacts that continue after this case was even filed in the form of contacts with a company called Propilco and a company, and their own records show that they were receiving profits from one of the companies that they contacted in 2014. And if you give me just a moment, I'll give you the actual pin site. But
was that, well, I mean, your complaint was filed in 2012.
Correct.
So how does the 2014 incidents that you're relating to now, or that you're mentioning now, relate to the claims as they were prior to September 13, 2012?
What our argument is that these actions don't accrue, these damages don't accrue, and the claim doesn't accrue until the actual one contact is made, and then we're damaged by that contact. The one incident that counsel points to, this Markham conversation, we have to remember that that's something that our principal learned about, contacted Mr. Usintosh and said, hey, what's going on here? And his response was, nothing to see here.
So again,
Won't
let me
happen
just
again.
ask you to pinpoint when you are going to allege or prove at trial your damages began. That's what we're looking at. When is your first damage? When are you claiming you first were damaged by this alleged misappropriation?
We put together an analysis that shows that we start feeling the impact of this in about 2009.
2009. When in 2009? Because obviously it's a 3-year statute. You commenced the suit in 2012. So if you're saying you were damaged in January 2009, you didn't commence until December 2012, there's an issue, right? So again, I'm going to ask you to be precise. When are you claiming your damages began to run on the on the misappropriation claim?
Well, the misappropriation claim is 3 or 6 years, depending on the conduct.
I'm just okay. I'm asking you again to tell me what it is that you are claiming.
And, and I apologize because I didn't bring all the briefs. We have the analysis
but
in the
that's
record.
a pretty basic part of your claim. The issue, the issue is statute of limitations.
We have.
Right? I didn't see anything in your documents that said when you are claiming the damages began. So that's why I'm asking you here.
We have a chart that has hundreds of trades on it, some of which are in 2009. And I believe, just to make it simple for Your Honor, I don't believe that the first trade is after the Mexichem conversation, if that's what you're asking about. I believe that there is.
I'm just asking, when you get to trial, when are you going to say your damages began? So that way we can evaluate whether or not your claim is time barred.
And I misspoke. There were damages in 2009 that I think would be more than 3 years before the complaint was filed. I think that's what you're really asking. However, we don't believe that that's a bar to those damages. And the law is clear that it's not one violation and one incident starts the clock running and it ends. It starts every time there's an incident. And so when we have incidents that are that occur.
So then what was the incident after June 30th, 2009 that would have restarted it?
After June 30th, 2009, there were hundreds, as I said, in our chart of incidents and in terms of damages. There, as I pointed out, and I can, again, give you the pin
That
side
chart
if you'd
that you're
like.
mentioning,
It's in the record.
It's in the record?
It's in the record, and it's mentioned in the briefs, and I apologize, in this day and age, we don't bring all of our paper with us, but I can give you the 2000, I did bring with me the 2013 email and the 2014 portion of the chart, thinking that that's what you wanted to hear. But while I'm finding that, I would like to point out that if there is any question in your minds that this was an employee of CIG, there might be something more difficult to pull out of the transcripts, and that is that in my deposition of Mr. Usintosh, he fully admitted that he was getting paid by CIG, not from 2004 to 2008, but from as early as 2002 to 2008. I didn't ask him about before 2002 only because it wasn't an issue in the case. I didn't know it was going to be an issue here. But now I'm looking at, for those pin sites, there's an email from Mr. Usintosh.
Well, you know what, you're going to have a minute for rebuttal, so why don't you look and you can give them to us during the rebuttal time.
A760 and A765.
Okay, thank you.
Your Honors, I'd like to respond to one point that Mr. Conway made. Based on the customer lists and supplier lists that they've produced in this case that are in the record, they're claiming that they started losing customers as a result of the alleged interference or misappropriation as early as 2008. They have claimed as damages all of those acts, and they started allegedly losing some of these customers due to interference from my clients, which has not been proven or shown. There's a correction. Mr. Conway
Counsel,
said...
let me ask you this. Do you agree with your adversary's position that the statute of limitations keeps starting anew every time there is a trade?
Again, it would have been, if there are separate acts of misappropriation and they're kept confidential, then there may be circumstances when that happens, but that's not been shown. All that's been shown is that we have done business with some of the same companies that they've done business with, and that's really all the evidence there is in the record. And, Your Honor, just to wrap it up, this is a case where they're seeking $28 million. It's been pending for 10 years, and there's been no showing. We're going to trial in January without any information, so if I may. Thank you, Your Honors.
Unless there are questions that you would like to ask me now, I'd like to just focus on the fact that there are a couple of claims here that we believe should have been, should not have been dismissed. If the aiding and abetting of the aiding and abetting claim, breach of fiduciary duty by Plasmar Markham, the evidence is pretty clear that they knew about this, that they encouraged Mr. Ustentosh to do what he did when he bought into their company in 2004, 4 years before he left. He was a mole. This is, everybody's looked at this evidence other than Judge Maisley has said, this is clear that there was knowledge, including knowledge on the part of the man who runs Plasmar, who has now got a judgment against him in the federal court based on that.
Sir, what evidence, in your view, raises a triable issue of fact on your cause of action for tortious interference with prospective economic advantage?
The tortious interference claim was, let's start with Equate. Equate was the biggest customer of the business. They actually informed us, that's how we knew about this case to begin with. In 2012, when we sued Equate because they breached an agreement with us, they said that they did it because of what they heard from Ustentosh and what they heard from other employees at Plasmar. And based on that, we lost that $100 million contract. And so, you know, if we just look at the one of dozens that they made us lose, that one.
Thank you, counsel.
Okay.
The next case is People versus, I'm sorry, Donson Nagy versus HC2 Holdings. Go ahead.
Good afternoon, Your Honors. My name is Tracy Appleton. I appear on behalf of my firm, Appellant Donson Fleissig, or DNF. This case presents a highly unusual circumstance because here the lower court got it right before it got it wrong.
Let me ask you, to me, one of the most important questions.
Certainly.
Is the dormancy doctrine still a viable doctrine at all after the enactment of the CPLR, which has very specific provisions addressing these issues and could arguably be the substitute for what the dormancy doctrine used to be?
Your Honor, just like any other common law doctrines, the dormancy doctrine is still an important doctrine to ensure that all creditors have the ability to collect money from a debtor. Without the dormancy doctrine, it is simply too easy for a particular creditor who happens to get there first to make a deal with the debtor or to act in a certain way that prevents.
Counsel, why isn't that, I mean, the dormancy doctrine, the cases are all very old and dated, and it's part of because no judges are applying it anymore. But why isn't that covered by the provision in the CPLR that in order to get an extension, you have to apply for it and the judge has to grant it? Why can't the judge consider the factors you're arguing the dormancy doctrine invokes when deciding and using its discretion to grant or not grant an extension of an execution?
Well, Your Honor, in this particular circumstance, that would be a distinction without a difference because here the city did move for an extension in December of 2020. It moved 8 days before the end of the current.
Right, so why couldn't the court just apply its discretion, looking at all the factors of the case, to decide whether or not it would be appropriate to grant an extension versus invoking this dormancy doctrine, which was enacted well before the enactment of the CPLR provisions and is arguably addressed by the CPLR provisions?
Your Honor, we're aware of no precedent indicating that the dormancy doctrine is no longer live. However, the court certainly has discretion when considering a request for an extension, and one of the things that it considers is how the creditor is related to the debtor, what the creditor has done in order to try to enforce its claim on the debtor. And the dormancy doctrine dictates, and we believe that is incorporated in what one would apply with respect to discretion. It incorporates the idea that it is improper for a creditor to make any kind of instruction to a sheriff, however veiled, to try to slow down or delay the either the execution of a levy or the sale of any particular property that might be targeted by other creditors. And so we believe that concept is included in the idea of deciding whether or not to allow an extension.
Let me ask you something. Let's putting aside the question of whether the dormancy doctrine is still a viable doctrine. Why wasn't it apparent from the record that the city was taking the steps it took, not in any way to benefit the judgment debtor, because the city was trying to maximize its own chances of getting paid on its debt, and it believed that the best way to get paid on the judgment was by making these accommodations to increase its chances? And what would be wrong with that if that's what was the motivation for the city's actions?
Respectfully, Your Honor, that is not a decision that the creditor is allowed to make. There is some discretion with respect to the sheriff. When the creditor comes in and tells the sheriff what to do, they are making their own unilateral decisions, not just for themselves as creditors, but for any other creditors who happen to be behind them on whether or not they'll be able to collect money. And if that guess is wrong, they're making that guess on behalf of any number of people who will not be able to collect from that debtor. So the idea is that the sheriff has some discretion.
Didn't the sheriff say that no one ever told him to delay executing on the sale? Isn't that his testimony?
Your Honor, after the city worked with the sheriff, who does work for the city, and had him sign a supplemental affidavit, he said very specifically that the city did not tell him that he should purposely delay. But in the affidavit that he signed in connection with working with us, and by the way, sheriff does not work for us, but in dealing with his own affidavit, he specifically says that he was told that the plan was to have the sheriff retain possession of the stock certificate for an unspecified period of time during which they hoped Mr. Falcone would satisfy the judgment from other assets. And he was told not to schedule a sale of the stock certificate after he received it without further instructions from the city.
Okay, you have time on rebuttal to further respond. Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the Court. Amy McCampbell on behalf of the city. Your Honors, we have found one case that has applied the dormancy doctrine in the last 100 years. And it's a New York City Municipal Court case. And in that case, and in every other case in which the doctrine has ever been applied, there have been very, very different facts from what we see here. For one thing, in that case and in every—
So the question, I think I'm going to ask you the question my colleague asked your adversary. Do you believe that the dormancy doctrine is still a good doctrine in light of the amendments to the CPLR?
Well, it certainly hasn't been used again. We found one case in the last 100 years, and I think the policy reasons behind it, again, the CPLR does address many of those concerns. And in all the cases that we've ever found that have ever applied the dormancy doctrine, the property has been left in the possession and control of the debtor. And here, the city promptly collected the HD2 stock as soon as it was due to Falcone as part of the March 2020,
But
March
he
2021.
was still receiving benefits of the stock. He was still able to vote and other things, right? I mean, the sheriff had the certificates, but he was still receiving the benefits.
Well, Your Honor, if there had been dividends, which there were not, they would have went to the city, and there was the city. It's in the record. The city talked to the attorneys for Falcone and for HC2, and they understood that the city's levy took precedence, that any dividends would redound to the city. If Falcone tried to sell the stock, which he didn't, the profits would go to the city. So there was no prejudice to anyone from the fact that he retained voting rights in the stock, because any profit from the stock would have went to the city, and the city had the right to sell it.
One of your friend's concerns, as I recall from the brief, was that although the levy had been affected and the shares were in the possession, the custody of the sheriff, because the shares had not been used to satisfy your judgment, interest continued to run on your judgment, which potentially took away from a recovery as a junior creditor.
Well, interest runs on every unsatisfied judgment. Interest continues to run on Donson's unsatisfied
Right,
judgment.
but because the shares weren't used to the shares weren't sold at an auction, and the proceeds used to satisfy your senior lien, interest continued to run on your judgment and potentially affected their ability to get a recovery from the shares.
So two things, Your Honor. First, the CPLR allows anyone to move for an immediate sale of property that the sheriff has collected. And Donson knew from September 2020 that the city had collected these shares. Page 98 of the record, Donson mentioned that in a letter to the court. Donson never sought an order for immediate sale. So that's point number one, Your Honor. And second, it's undisputed that when the city did sell the stock in early 2021, the price of the stock had gone up from where it was during the low of the pandemic. And by getting an order to sell the stock via a stockbroker, it's also undisputed that the price the city obtained was higher than was expected to be obtained via public auction. And once the city sold the stock, it was able to fully satisfy its judgment. And my understanding is the excess was remitted to Donson as a next-in-line judgment creditor. So what the city did here made sense, and it does not implicate the dormancy doctrine, where, again, the property was collected as soon as possible, and there was no positive direction from the city to ever delay anything, the execution and the levy, Your Honor.
But under the Excelsior case that they cite in their brief from the 4th Department, I think 1900, it seemed to me that the dormancy doctrine would be triggered anytime there was a direction from the senior judgment creditor to the sheriff, preventing the sheriff or instructing the sheriff not to go forward with the levy or the sale. And so really the motive or the intent behind the instruction, based on my reading of Excelsior, wasn't germane. It was the fact the instruction was given that triggered the dormancy doctrine.
Yes, Your Honor, and there's no instruction here. We know that because the sheriff's affidavit, in which he, quote, unequivocally states that at no point did anyone from the city ever direct a delay of the levy or the sale. That's 463 of the record. We know there was no delay because of the multiple affirmations from city attorneys that say the same thing, that there was no instruction to delay. We know that because of the contemporaneous evidence. The directions from the sheriff to the debtor and the garnishee expressly reserve the sheriff's right to sell the stock at any time. And the email that from the city, contemporaneous email from the city, page 298 of the record, we see that language was added by the city to make clear to all the parties that the sheriff was not representing that he was going to forbear on selling the stock.
What about
the record is clear.
What about in the initial affidavit from the sheriff? I believe at page 268 of the record, the initial affidavit contained a statement from the sheriff to the effect that the city lawyers told the sheriff not to schedule a sale of stock until they received further instructions from Corp Counsel.
Sure, Your Honor. So I'll say two things in response. I see I'm out of time, but just to briefly address your question, Donson interprets that as an indication that the city impliedly told the sheriff to delay. But the sheriff, again, unequivocally rejects that interpretation in his second affidavit, page 463 of the record, where he says there was no instruction to delay. And he also says that that particular passage is not a verbatim quote from the city attorney. It's a summary that's consistent with the kinds of conversations that he has with judgment creditors and judgment debtors, because it's typical for there to be extended conversations about the mechanism of sale. So there's nothing unusual here whatsoever, Your Honor, and there's certainly nothing to trigger the dormancy doctrine. We ask this court to affirm. Thank you.
Thank you.
Thank you, Your Honors. Just a few points in response. Saying that what he said in the first affirmation is not verbatim is not the same thing as repudiation. In no way did the second affirmation ever repudiate what was in the first affirmation. That detail is there. He swore to it. He meant it. He never said that he lied or made any kind of mistake. Earlier, there was a comment about...
What does the dormancy doctrine, what protections, if any, does it provide to junior creditors that's not accounted for or provided by the CPLR?
Your Honor, the protection that it provides is to prevent there from being any kind of direction that is going to slow down a sheriff. That idea in particular, we believe, is not addressed by the CPLR, and I'd like to comment on one point in particular that's related.
Isn't that provided for in the CPLR by what my colleague said before, that the judge has discretion to deny an application for an extension?
And that's precisely what the judge did here before the city pressured the judge into changing his mind. And so, as we discussed before, it's a distinction without a difference in this case. But just a perfect example is something that was brought up a moment ago, which is the idea that DNF was aware that these shares were in the sheriff's possession, and DNF was aware in September. What DNF did not know was that there was an agreement that was stopping the sheriff from actually selling the shares. It did not find that out until March. Literally, in the hearing transcript, you can see that they received those shares.
Well, what difference did that make? If you knew at a certain point that the sheriff was in possession of the shares but not acting to schedule a sale, what difference did it make, the reason for that? If you wanted to expedite a sale, your friend mentioned that there's a provision within Article 52 that would have permitted you to prompt the sale. So what difference does it make, whatever the reason or rationale or motive for the sheriff not going forward with the sale at the time you knew that he was in possession of those shares?
Your Honor, when one is pursuing payment on a debt, the amount of time and energy that one spends is simply, throwing money down a hole if you don't actually collect. Expecting other creditors, and I'll just finish answering your Honor's question, expecting the other creditors to show up and to make motions because someone has made a deal behind the scenes that they are not aware of is not how this is supposed to work. That's why the dormancy doctrine was applied, and yes, it was applied many years ago, but it's been around for a long time. It's still cited in treatises for a reason, because it makes sure that people are able to collect money, that they're able to collect as much as possible from debtors, both in fairness to the debtors and in fairness to other creditors as well.
Thank you very much.
Thank you, Your Honors.
The next case is People versus Cruz, and Justice Rodriguez is disqualified.
Good afternoon, Your Honor. Scott Eckel, Kramer 11, pro bono counsel for appellant Hector Cruz, serving as co-counsel to the Legal Aid Society. May it please the court. This is the case about a father who has already served 4+ years of having his freedom restricted on probation and has worked hard to get his life back on track after making a single mistake, who was excessively given the maximum probation sentence for a 29-year-old.
Counsel, this was an SCI plea, correct?
Yes.
So it was presumably negotiated in the anticipation that the charges wouldn't be presented to the grand jury, correct?
Correct.
And so in exchange for that, as opposed to the prison time that he faced on what was a D or C felony, he got probation. Granted, there's a 3, 4, or 5 year probation that he could get, but he didn't get prison time, right? That was what was negotiated?
Correct. He didn't get prison time.
Okay.
But again, Your Honor, this court has the ability to review plea bargains and in its interest of justice authority can rule that even a sentence in a plea bargain is excessive under the circumstances. And here...
Counsel, was there a waiver?
There was an attempt at a waiver, but the waiver was...
What are you alleging was wrong with the waiver?
So the court, in the plea colloquy, said that most claims of error, and that nowhere did the court explain Mr. Cruz was giving up the right to appeal beyond error, beyond abuse of discretion, have this court review the sentence in the interest of justice. He only said most claims of error, and that could have meant procedural errors, not the separate avenue of appeal, which is the interest of justice jurisdiction. Going back to the merits of the case, he received the maximum sentence, and yet he had no significant criminal history prior to the guilty plea. This is his first and only felony conviction. He was making efforts to support his then girlfriend and infant daughter at the time of sentencing. He took responsibility right away for his actions, and there was no prior history of any violence or felonies. He did not pose any danger to society. Mr. Cruz was also receiving financial support from his mother and sister. There were no there were no allegations of weapons having been involved here. Even the complainant was okay with Mr. Cruz receiving a non-incarceratory sentence.
Which he received?
He didn't go to prison, no.
Okay.
Again, this is the exact type of person who courts have often reduced excessive sentences before, and we're asking for the court to reduce the sentence to the minimum 3 years because the sentence was excessive. Thank you.
Thank you very much.
Good afternoon. May it please the court. ADA Nicole Nichols for the Office of Darcel D. Clark. Initially, defendants request that this court reduces his probationary sentence in the interest of justice is foreclosed by the valid waiver of the right to appeal. The court's colloquy clearly informed defendant that he was waiving the right to appeal as part of this negotiated plea. Nothing in the court's colloquy was confusing, and the court did not have to tell defendant that he was waiving the interest of justice jurisdiction of this court. The Court of Appeals has not made that part of the court's colloquy, and there's no reason for that to be here. The critical question is whether the defendant understood the right that he was waiving, and this record makes clear that the defendant did. Nevertheless, a reduction of the sentence is not warranted. As this court stated, the defendant has already received an extremely lenient sentence for what was a violent felony. Defendant and his friends or co-defendants attacked this complainant. They punched him in the head and the face repeatedly. When he fell to the ground, they kicked him repeatedly, and then the defendant rifled through his pockets, stole his money, cell phone, credit card, and identification. Those items were found on the defendant at the time of arrest.
Counsel, what was the defendant's sentencing exposure if he hadn't taken the SCI plea and went forward on the charge of attempted rob too?
On the attempted rob, he faced 2 to 7. If he hadn't taken a plea and he had pled to and he got convicted of the trial of the top count, second-degree rob, he faced 3.5 to 15. Instead, defendant got a non-incarceratory term of 5 years. And that extended, while it is the maximum term, it was appropriate in this case. Again, defendant's conduct was serious. Defendant had showed that he was a risk of reoffense in that defendant did not have steady employment. Defendant indicated that he used marijuana and alcohol on a daily basis. This is the defendant that would benefit from extended supervision, and that was what happened here. We asked that defendant's negotiated sentence was fair, and we asked that his judgment be affirmed.
Thank you very much.
Just to address what the Honor was talking about before, he did receive a probationary sentence over prison sentence, but again, it was the maximum sentence of probation, which was not warranted here. This court again has...
Well, probation presumably was the negotiated plea, and when they negotiated, they didn't negotiate for 3-4 years of probation. They negotiated for 5, as opposed to prison time. I think that's the point that I'm trying to make.
Yes, that may be true, Your Honor, but again, This court has the ability to look at plea bargains and determine if it was excessive based on the factors here. Again, he had no prior criminal history. This was his first and only felony conviction. And what was brought up by the respondent, again, Mr. Cruz was not at risk to reoffend. He was making efforts to support his then girlfriend and infant daughter. He had financial support from his mother and sister. He had a steady history of employment. He was not employed at the time, but he did have a steady history of employment. There was no evidence of prior violence or prior risk to offend. And if I can just make a note that the goals of probation are ultimately rehabilitative in nature, not deterrent and punitive. Thank you.
Counsel, thank you very much for your pro bono service in this matter.
Thank you.
The next case is Rodriguez versus Consolidated Edison.
May it please the court, my name is John Marr from Cravat Hofer Marr for the plaintiff appellant Angela Rodriguez. Madam, I'm asking that the court reverse the lower court and grant plaintiff's motion to renew, and upon renewal, deny the motion for summary judgment made by the contractor respondents herein. I think the court below, the error they made is that they lumped the plaintiff in with Con Ed in this.
Let me ask you about that, because obviously you have to show a reasonable justification for your failure to move earlier to satisfy a renewal motion. And I do appreciate that Con Ed and plaintiff are different positions, because Con Ed actually had the document. But once Con Ed testified at the deposition about the document, wasn't there some obligation on the part of plaintiff to pursue obtaining the document?
They didn't testify about the document, Your Honor. There are several documents. It's very complicated, but I would note that the respondents are very well aware of how to use Con Ed documents. There was no testimony whatsoever about the layout that Con Ed served on the plaintiff after the note of issue.
Well, they testified that there was a layout document, and did plaintiff ever ask for a copy of that layout document that was testified to at the deposition?
Well, we were provided several layout documents, and they're all ideations of other documents, and we were never provided, though, this one that was 6 mm. It ended in 6 mm, and it was never provided throughout all of the discovery.
And is your position that it was never, that this particular layout document was never referenced or referred to in the deposition?
Correct.
Its existence mentioned?
That's right, Your Honor.
So, counsel, when I look at the deposition, the transcript that says, there is a layout number on that document, plaintiff's 4 from 12/13/12, there would have to be a layout document. Is that fair? If the work was done, yes, right? So that's the layout document that you were produced. That comes from the deposition testimony in 2016.
Right, Your Honor, but
After that, did you ever make a request for that layout document post-EBT?
we did, Your Honor, and so did Triumph. If I'll just refer to Record 968. Triumph requests layout documents. Again, they all have very similar numbers, and they end in different M's. So you have 2M, 3M, 4M, 5M, and all of those were produced, 2M, 3M, 4M, 5M, but not 6M. 6M was never produced. And then it was only after summary judgment was granted to the two contractors, 2 months later, that Con Ed, with unsolicited, by the way, note of issue had been filed more than a year before, Con Ed says, pursuant to the rules of discovery, here is 6M for the first time, and they acknowledged that, it just...
So your position is that the layout that was testified to in 2016 had the identification number 2M, but the 6M layout, which is the relevant one, wasn't turned over until 2019 when Con Ed, on their own volition, just turned it over.
That's correct, Your Honor.
Okay, thank you.
Thank you very much.
May it please the court, my name is Dan Ratner. I'm here on behalf of Con Edison.
The facts that co-counsel just laid out is correct. Con Edison turned over this document a few months after the initial summary judgment motion was decided.
Was the document, what is your position as to whether this document was not mentioned at the deposition?
It wasn't. It was the wrong layout had been provided at that point, and it was.
Was there never a request for all layout documents having to do with this location?
Yeah, if you've noticed in my brief, we're not offering an excuse. We turned it over late.
But what, I get that, but I'm asking both as to you and the plaintiff, why was it turned over late? Was it never requested before by anybody?
I think when we did our document search initially, that is, Con Edison did its initial search, it just didn't turn up. And then after the summary judgment motion was granted, another search was performed, and this one turned up. That's basically what happened here. And that's
So your position is it is newly discovered evidence because it wasn't found before, but what was the due diligence that was undertaken? Like, why was it missed in the other document production?
The record does not reveal an answer to that question, Your Honor, I'm afraid to say. Our position is, however, that there's no doubt whatsoever at this point in the proceedings that Nico and Triumph did do work at the location of the fall. No one's denying that. Plaintiff is arguing it was a late disclosure. Excuse me, co-defendants are arguing that it was too little, too late, and therefore the motion should be denied. But we're asking, in the interest of justice and fundamental fairness, that renewal be granted, and we have a trial on these issues. Unless there are any further questions, I'll rest in my brief. Thank you.
May it please the court, Michelle Gelman for Respondent Triumph Construction Corporation. I think counsel has essentially admitted one of our arguments that there is no reasonable delay or excuse for having not turned over said document. One thing that was missing from both of my colleagues' arguments is after Triumph was granted summary judgment in December of 2018, there was a motion to re-argue made by Triumph as to Con Ed's claims. The initial summary judgment motion only.
Well, I guess the question really is, though, is particularly pertaining to the plaintiff. If these documents weren't turned over until 2019, documents that were in exclusive control of Con Edison, now we're finding now, and I guess the record will reflect if this is correct, that the 2M document that was testified to is not, in fact, the 6M document, which is relevant to this claim. Why isn't that newly discovered evidence for which the Supreme Court should have considered on the motion to renew?
Your Honor, we're not saying that had it been disclosed in a timely fashion, and even by plaintiff's own tactics, he knew about this document in February of 2019, and then even took a further deposition and engaged in discovery. We were out of the case at this point with counsel, and this continues to wait to even make the motion to renew until May of 2020. At some point, this becomes prejudicial to my client.
How long are you saying it's a time frame between when he first knew about the document and when he made the motion for renewal?
February of 2019 was the time that the document first, or plaintiff became aware of the document from Con Ed advising him, and the motion to renew was made on May 5th, 2020. So our argument is there was not only numerous time for Con Ed to disclose this document, made a motion for summary judgment, it wasn't used in opposition. We made a motion to re-argue to dismiss Con Ed's claims. At that point, there was no opposition, never mind from Con Ed with the document, there was not even any opposition from the plaintiff at that point either. And then, supposedly, the document surfaces in February of 2019, and all of a sudden, we wait and wait and wait, and now, finally, in May of 2020, comes the motion to renew.
If we consider 6M, does it change the outcome?
I don't believe it does. Triumph has not produced any records, nor did we locate any records thus far. Our testimony, based on not only our records, but Con Ed opening tickets and an as-constructed document that the Con Ed witness testified to, showing a darker line, meaning as constructed, you know, we might have these parameters to work in, but here's where you actually did your work. All of the testimony that is the case, law of this case, shows Triumph was 70 feet east of the defect location.
Let me ask one last question. Do you have any position as to whether the document that was subsequently produced was the document referred to by Con Ed in the 2016 deposition?
I don't believe it was. There were other layouts that Mr. Russo testified to that coincided with our opening ticket.
So that the first time plaintiff would have become aware of the layout document was in February 2019 when it was first produced by Con Ed?
Possibly, Your Honor. I know there was some testimony throughout the record that Con Ed was arguing that said they believe said layout would have been exchanged prior to their initial deposition back in 2012.
Okay, thank you.
Thank you.
Good afternoon. May it please the court. Mary Azzaretto for Respondent Nico. In addition to the arguments of Triumph, which I adopt, I also want to bring to the court's attention that exactly 1 week ago, this court issued a decision on a case which had basically precisely the same issues we're dealing with here. The name of the case is Boglin versus New York City Housing Authority. In that case, summary judgment was granted to the Housing Authority. Plaintiff moved to renew. The basis for that motion was that there was a work order that was not submitted earlier because it was buried in discovery motion papers, and they simply did not find it in time. This court affirmed the lower court's decision, which held that they simply did not provide a reasonable justification for not providing the information earlier.
So, counsel, let me ask you, what is your position with respect to whether or not the document, if assumed that it was produced timely, would have changed the outcome?
It would not have changed the outcome.
And why is that?
Well, as Mr. Russo, who testified numerous times in this case, said at his first deposition, the as-constructed document is the best description of the work that was performed in that location. He reviewed that document and affirmatively testified that no work was performed by Triumph or Nico.
And does the document that was produced late show something different?
To be honest, I don't know what the document that was produced late shows, and the reason for that is because my client was not a party to this action when it was produced. As plaintiff's counsel says in their brief, it's not a self-authenticating document, and I'm certainly not an expert in what those documents show. But to bring back defendants who were let out of the case 2 years ago due to the fact that one party just did not disclose it due to an error, and the other didn't do their due diligence to get it, would result in substantial prejudice to the respondents in this case.
Thank you very much.
Thank you.
Counsel, can you just address the fact that this document was turned over in February of 2019, but the motion to renew was not made until May of 2020? And we understand that the pandemic started in March, but even though there's still a significant amount of time.
Absolutely, Your Honor. The document that was originally turned over in February of 2019 was a document 207-6883-6M-ADV. And what that actually was a document that showed electrical wiring being put in a conduit. Okay, so there was already construction. There had already been a dig out there and conduit already installed. So that was the first document they provided. We were required to make a motion to get Con Ed to produce a witness again, Mr. Russo again, who had been previous. That motion was resolved by a stipulation on 9/19/19. We then held the deposition of Mr. Russo on 11/4/19. At that time, Mr. Russo said there should be another document, another 6M document, but not 6M advanced. It would be 6MM, and that would show the actual construction where they actually dug out the hole. So we made a post-DBT demand on 12/27/19, and then we also forced an additional deposition of Mr. Russo on February 10th, 2020, at which time Mr. Russo testified that they produced those documents at the deposition, those 6M documents, and Mr. Russo, the Con Ed witness, who was also the person who actually worked on that site, Mr. Russo said, yes, this shows that there was construction there, the construction was done by Triumph, and that the end result, putting the asphalt down was done by Nico. Absolutely, these documents changed the outcome of this case. The defendant's motions were granted on the fact that there's no evidence that we were at the scene. The testimony of Mr. Russo and the records that are in the record that were all provided to me post that decision, post them getting out on summary judgment, all indicate that they actually did the work. And there's virtually no question about it, based on the records. And I wanted to point out, Your Honor, counsel made reference to the as-built documents, both counsel did. I'll ask your court to look at page 476, is the as-constructed document. And if you look in the upper left-hand corner, you'll see that it's a 2M document, not a 6M document. It is for 207-6883 2M, which is the problem. 2M's the wrong place. And Mr. Russo testified about that in the subsequent depositions after the motion was granted.
Thank you
Sir,
very much.
what more, if anything, could you have done to obtain this document 6M prior to when you received it?
We didn't know it existed, Your Honor. That's the problem. We didn't know the note of issue had been filed. We were forced to file a note of issue, and we were quite aware that, hey, we have very sketchy facts here, but there was a lot of construction done on that street. And counsels, respectfully, the defendant's motion mixed this as-built document and said, hey, look, we have an as-built document. It's the best thing you can look at. It's 70 feet away. We should win. And the court accepted that, and that's the way this decision went. You have nothing further, Your Honors?
Thank you.
I really actually have nothing to add. Thank you, Your Honor.
Okay. The next case is Calnet versus 141 East 88th.
Good afternoon, Your Honors. May it please the court, my name is Andrew Showers. On behalf of the defendant appellant respondent, DJM, NYC LLC. This action is an attempt by the plaintiff to undo her notice of claim and 50H hearing testimony where the cause of the accident was exclusively a tree well, and there was no mention of a sidewalk shed being involved. It is respectfully submitted that DJM should have been dismissed from this case in the lower court, and thus we respectfully submit that the lower court order should be reversed. Plaintiff testified that her foot went into an irregular side of the tree well. I didn't step in the tree well, I stepped on the sidewalk, and the tree well was not level. It's not until months later that there was a new theory interjected into this case that the sidewalk shed was somehow involved. My client was not negligent, and it's respectfully submitted that we should have been dismissed in this case.
Well, is your argument that you were not negligent, that any negligence on your part was not a proximate cause, or both?
We weren't negligent. The sidewalk shed was not the proximate cause of plaintiff's accident. By her own testimony, by the notice of claim, the sole exclusive cause of the accident was her stepping on a unlevel sidewalk and into a depressed tree well, both of which are the responsibility of the City of New York and or the property owner, but not my client, Your Honor.
But as to proximate cause, the theory is that the presence of the sidewalk shed, the scaffolding equipment, what have you, sort of funneled or compelled plaintiff into the defect.
Not at all, Your Honor. The plaintiff was approaching the sidewalk shed. She had no contact whatsoever with the sidewalk shed. She was in the bright sunshine walking toward the sidewalk shed. There's absolutely no basis for this lawsuit against my client. There's no interaction whatsoever with the sidewalk shed, no contact whatsoever with the sidewalk shed. And any testimony after the notice of claim or the 50H hearing is just feigned testimony, Your Honor, respectfully.
Thank you.
Thank you.
Good afternoon, Your Honors. My name is Lisa Fleischman, and I represent Rock Group, who is the entity that put up the scaffolding or had a subcontractor do that. Your Honors, this started as a tree well case, and then it became a negligent placement of the bridge leg case. But in reality, this has always been a tree well case. And for that reason, Rock Group demonstrated its entitlement to summary judgment. They demonstrated that they had no duty of care owed to the plaintiff, that they assumed no duty of care under the Espinal factors, that they committed no negligent act, and that no act proximately caused the plaintiff to fall. We proved prima facie, and the plaintiff did not come back and create an issue of fact. It is undisputed that the plaintiff chose to go left when they came to the bridge leg. And that is a key fact, Your Honors, because it demonstrates that the plaintiff could have gone left, could have gone right, could have waited for the pedestrians to come, or her and her husband could have gone single file. This is not a situation where the sidewalk was obstructed or split into pathways. And the fact that she had the choice to move about and had the entire expanse of the sidewalk ahead of her distinguishes the plaintiff's cases from the cases upon which we rely, and I'd point, Your Honors, to the Wood case, the Young case, and the Lopez case, in which this court found that where the pedestrian was not compelled or forced and diverted to a defect, that the defect or alleged defect was not the proximate cause for the accident. And I submit to you that that really is the key factor here. It is also undisputed that the plaintiff herself testified that she fell because her foot went down on the sunken paver. And that is a very significant fact in this case. At the end of the day, Your Honors, at the very most, the bridge leg merely furnished the occasion for the plaintiff's accident. The bridge leg was perfectly fine, perfectly safe. There were no violations issued with respect to it. Nobody made any complaints about the leg or its placement. It did not narrow the sidewalk. It was simply there in front of pedestrians. It did not obstruct it. It did not violate code. Plaintiffs offered an expert affidavit from an expert who didn't inspect the scene, and offered photographs of post-accident scaffolding, which is impermissible, and discussed code provisions that were not in the Bill of Particulars. And so the expert affidavit should be disregarded for all of those reasons. But, Your Honors, in any event, Rock Group did not violate any of those code provisions. There was no narrowing to less than 5 feet of the sidewalk. The sidewalk was completely available to the pedestrians. They simply had to choose whether to move right or left. Your Honors, I would also like to point out to you that Rock Group did not deviate from the design that was submitted to the Department of Buildings and approved. I would point Your Honors' attention to the testimony of Kevin Williams, who was an operative of DJM at pages 516 to 519, in which he testified that the drawings don't show all of the legs, the bridge legs. They only show typical leg spacings, where typically the bridge legs are installed. It is up to the installer, according to Mr. Williams, Kevin Williams, because there are two, that the installer decides where to put the bridge legs. And also the operative from Rock Group, Mr. Prabhat Singh, testifies to the very same thing at 758 and 60, that the legs are typical legs. If it's a typical scaffold, in other words, not a custom scaffold, and this was a typical scaffold, according to Mr. Singh, the legs are placed wherever the installer finds the place to put it, the appropriate place to put it. So here, the scaffold was constructed in accordance with the plans that Rock Group submitted to the Department of Buildings. There's no code violations, there's no deviation from the plans, the leg is safe, there's no complaints about it, there's no violations issued, and at the end of the day, this leg had nothing to do with the plaintiff's fall. At most, it merely furnished the occasion for the fall. If Your Honors have no questions, thank you.
Thank you very much.
Good afternoon, Your Honors. May it please the Court. Irina Kravchenko, I represent defendant, respondent, appellant Philip House on this appeal. I will adopt my colleagues' arguments regarding proximate cause. I would just like to add that with respect to Philip House, who was the owner of the premises, the complaint should also have been dismissed because it lacked actual and constructive notice of the alleged illegal narrowing, to use plaintiff's words. This Court's decision in Lopez versus Dagan, 9883rd 436 in 2012 is directly on point. There, the plaintiff fell through temporary flooring that collapsed. This Court, with respect to actual notice, held that there was no evidence that the owner knew the floor was improperly installed or structurally deficient. As to constructive notice, it held that, and I quote, "Nothing in the record indicates that the floor, when viewed and stood upon, appeared to feel compromised." This is exactly what happened here. Philip House hired DGM to perform restoration in a workmanlike manner in accordance with the regulations. There was plans approved by the DOB. The shed was installed in accordance with those plans. The DOB actually conducted inspections. There were no violations issues. There were no prior complaints. There were no prior accident. Philip House had no actual notice that this presented any danger. Additionally, the sidewalk shed appeared perfectly it was in good condition. There was nothing actually physically wrong with it. Therefore, any defect or any alleged narrowing, it was a latent condition that could not have been readily observed, and therefore there was no constructive notice because that is a prerequisite to it. Now, finally, just another point is that Philip House is also entitled to contractual indemnification from DGM simply by virtue of plaintiff's allegations or assertions, to use the language in the contract, that Philip House is liable as a result of DGM's work-related activities, and involvement with the project. Unless the bench has any other questions, I'll rest on my brief.
Thank you very much.
Thank you.
Good afternoon, Your Honors. Excuse me. My name is Andrea Krugman. I'm here on behalf of the plaintiff, Calnet. A few things. First, there is absolutely no attempt by the plaintiff to undo her 50H testimony nor her notice of claim. The notice of claim is simply to put the City of New York on notice.
So why don't we focus on the issue of proximate cause, which is one of the biggest issues in this case?
Sure.
How was the placement of the sidewalk shed the proximate cause of the injuries, where it's undisputed that she could have chosen to walk on the other side of the pole, her and her husband could have each walked on one side. There were many different options that could have avoided her having to go into the tree well. So how was the shed the proximate cause?
The shed was erected in violation of Building Code 3307, and I'll explain how that leads to proximate cause. Because there is supposed to be a 5-foot wide pathway.
Isn't it 5 foot wide?
It is not.
It is, so how can you tell that?
So in the location, if you look at the photos, and sorry, I don't know.
I did, I looked at the photos, right?
So
And
the
at the
initial photos,
time, right?
in the area of the tree well, exactly next to the tree well, there is an area of only 3 feet.
No,
between,
across the sidewalk, right? There's 5 feet across the sidewalk. Is that not correct?
That is not correct.
So you're saying from where the shed starts to the tree well, including the little pole, is not 5 feet?
Well, you can't not include the little pole. You have to include the little pole because the little pole makes the, you can't walk into the pole.
Where, so,
avoid the pole.
right, so where is your evidence that that whole area wasn't 5 feet?
So the plaintiff's testimony is that between the edge of the tree well and the first leg of the pole is 3 feet.
Right, so assuming then you got the pole and then you have another area, right?
But the building code says it has to be free of obstruction. A sidewalk shed pole is an obstruction. It says you have to have 5 feet wide, free of obstruction. So it was impractical to put the sidewalk shed pole down the center of the sidewalk, thereby...
Let's say, for purposes of our argument today, that it was a violation of the administrative code. It's still the same question. Why was it the proximate cause of the accident? Why, if they'd each walked around one side of the pole or each walked on the other side of the pole, the accident wouldn't have happened. So
Because
It was the
ultimately,
occasion for, but why was it the cause of it?
well, it more than furnishes the occasion. It's, the distinguishing factor is, it's not like furnishing the occasion like snow did in the, not the Chapelveda case, there was another second department case. But in Wood also, they didn't have an expert that says, ultimately, it was up to the defendants to prove that that the sidewalk shed placement, one, was in accordance with the permits that were approved by the city of New York, and two, that it did not violate the building.
But again, you still haven't said, how was it the proximate cause? Could not the plaintiff have simply walked on the other side of the pole and not fell in the tree well?
Because there were other people on the other side of the pole.
Right, so she could have waited for 30 seconds, or she could have not walked with her husband in tandem.
But if you were,
So again, how is the placement of the pole the proximate cause of her accident?
because the placement of the pole made the sidewalk more dangerous. They weren't necessarily responsible for the tree well itself, but they have an obligation to not make the sidewalk less safe. And that's the Espinal case. If the tree well is there and the defendants are not responsible for the tree well, plaintiff never claims that the defendants are responsible for the tree well.
So again, if the plaintiff had walked on the other side of the pole, not the side that she walked on, but the other side of the pole, right? The pole would have, the same issues would have occurred, but plaintiff's accident would not have occurred, correct?
Because the tree well wasn't there.
Right.
So because of the dangerous condition that was on the
So it's the tree well, right, that causes the
combination.
plaintiff's action.
But if it wasn't for the sidewalk shed pole that narrowed the sidewalk,
Well, couldn't she have just gone on the other side?
she couldn't have because there were other people
Okay,
there.
couldn't she have waited 10 seconds and gone on the other side?
If they had narrowed it to 1 foot, would that have made a
I'm
difference?
asking, but you're saying that that is the reason. I'm trying to figure out why you think that's the reason she was injured.
Because they placed the sidewalk shed in a place that narrowed the sidewalk that made it a more dangerous condition. They made the sidewalk less safe for pedestrians to traverse.
Thank you very much.
Thank you.
Thank you.
Your Honors, with respect to the claim for contractual indemnity asserted by the Phillips House, we argue that on behalf of DJM that there is no entitlement to contractual indemnity. If the plaintiff's testimony is to be believed, then the Phillips House would be solely responsible for the uneven sidewalk and for the depression.
Counsel, isn't the only requirement for indemnification that the claim arise out of an act of DJM? And the argument here is that the plaintiff's claim in this case arose out of her allegation that the shed caused the accident or was the cause of the accident, which clearly was DJM's act.
No, Your Honor, we did not erect the shed. We had nothing to do with the shed. And furthermore, the plaintiff's claim in this case
What did DJM do there?
we're the general contractor. The erector of the shed was Rock Group. So we did not,
You're the general contractor who hired the subcontractor to do the shed, right? I mean, it was part of the scope of the work? It wasn't?
The scope of our work, Your Honor, was the brick work on the building. Scope of our work was not the erection of the shed. The shed and the permit was issued to Rock Group.
Okay, thank
And
you.
furthermore, the shed was not the proximate cause of this accident.
Who retained Rock Group?
We retained Rock Group, Your Honor.
Thank you.
Thank you.
Your Honor, I'll just stand to make the point that with respect to the fact that, or the argument that the placement of the pole made the sidewalk more dangerous, approximate cause has to be a substantial event. And the pole, the placement of the pole, was not a substantial event that caused the plaintiff to trip and fall. It was the sunken brick. If Your Honors have no questions, I'll rest on my briefs. Thank you.
Thank you very much.
Your Honors, I will waive the rebuttal unless the bench has questions.
Thank you very much. The next case is Mafi and Arana. Go ahead.
Good afternoon, Your Honors. May it please the Court, my name is Anna Huang, and I am here on behalf of Defendant Appellant JM Manufacturing Company, Inc. Now, as you can see from both of these briefs in Maffei and for Arana, that all of the documents here are the same. We're talking about the same product, the same company. We distributed for 5 years from 1983 to 1988 a subsoil underground pipe. And as you can see from the documents submitted by plaintiff, by the documents submitted by JMM in this case, appealing Justice Severa's punitive damages decision.
Well, counsel, before you, I want to turn to Plaintiff Arana and his claim. Just so I understand, the pipes that, these are sewer pipes, underground pipes that
Correct.
JMM manufactures? And plaintiff...
Not manufactured, distributed.
Distributes, thank you. Plaintiff Arana's testimony is that he worked in homes that were built within a certain period of time, and these pipes were in the basement.
Correct.
Did Plaintiff Arana testify that he also worked with these pipes in the basement, or because these are sewer pipes, they were not necessarily connected to the work he was doing?
So the plaintiff testified that he started working in the late 1999 to 2000s on basements. Now, one thing that he doesn't testify is that there was never any trenching involved. They never dig the earth. We are subsoil product. And so what that means is you need a permit for our product to install it in the ground. When you go into any Queens basement or any residential basement in the state of New York, you will find that the pipes are not asbestos cement pipes. And that is because of the building codes of the state of New York. There are numerous building codes in the state of New York, whether it's the standard business codes, the plumbing codes. These are subsoil drains, so it needs to be underground. So if you go into any basement and you're looking at sewer or any kind of piping within the home, so above the ground, that is not our product, Your Honor. And that is the crux of the Arana appeal in terms of it could not have been our product because for it to be our product, you have to look at it in a vacuum where there are no codes, where there are no engineers that know the codes, there are no inspectors inspecting the product so that it is in compliance with the codes. And so in order for this to happen, for someone to go into a basement, there has to be no codes in the state of New York regarding plumbing, because all of the codes in the state of New York say that asbestos cement pipe is a subsoil product.
So wait, so you're saying that if plaintiff testified that he personally removed pipes that were labeled J&M transit pipe or John Mansville transit pipe by cutting out sewer pipes with a sawzall? I mean, that's what he testified, right?
Correct.
So why doesn't that raise an issue of fact?
Well, Your Honor, I think in a motion for summary judgment, or when a plaintiff has a claim against JMM or any defendant, you can't have a claim based on speculation. You can't have a claim that...
Oh, that's his testimony. He says, I cut out basement pipes with a saw that said J&M on them. Again, I'm asking you, it might be a complete and total lie. So, why doesn't that raise an issue of fact?
There are 2 points, Your Honor. So one of the issues is he testified to JM Transite. It's my understanding that first in the 50s, 60s, 70s, all the way up until 1980, there was Johns Manville. It's my understanding that Johns Manville had Johns Manville and JM Transite. And so by someone saying in the late 1990s and the 2000s that, oh, I can look at these pipes. I know when the houses were built, by just looking at the houses, I know that these pipes were installed originally to the homes. And so just because there's JM Transite on the pipe doesn't mean it was distributed by JM Manufacturing. If you look at the court documents, there was Johns Manville prior to we purchased the PVC section from the bankruptcy, and so there was Johns Manville prior to 1983. So December 30th, January 1st, that's the distinction. And so we are not liable for anything that is Johns Manville. At this time, when you're looking at a pipe that's already existing in the ground, how do you know
What about the
when?
allegation, though, that there was testimony by a former employee that significant quantities of Johns Manville pipe were left at the time of the corporate transfer, commingled with the pipes manufactured by JMAC and distributed by JMM for years after its purchase of the business? Why wouldn't that allegation be enough to raise a factual issue about what pipe this plaintiff was working on?
And I believe Your Honor is referring to Mr. Armstrong's testimony.
Armstrong, yes.
And if you look at the actual language of the bankruptcy order in 1982, December 25th, I believe, it says that all of the inventory transferred, everything that is Johns Manville stays with Johns Manville. And so that inventory, that's all of the liens, the claims on everything that was transferred, that stays with.
You're talking about the liability now, right?
Yes.
My question is about actual product. There's an allegation that actual product was transferred over, which is different than liability. So the fact that there's an allegation that actual product of Johns Manville was transferred to these corporations and they distribute it, even if it was Johns Manville product that was in the basement, why wouldn't that still raise an issue of fact then based on the allegation?
Well, Your Honor, I believe it would be based on speculation. A claim can't move forward based on speculation, and the fact that there may have been inventory that could have been surplus from California or Texas into New York, into our basements in the 1980s, I think that's based on speculation. We don't know.
Okay, thank you very much.
Good afternoon. Jason Weinstein for the plaintiff respondents in these matters. Just to make clear, as the court recognized, Mr. Arana specifically testified that in the basements where he worked, he found and encountered and was exposed to asbestos dust from pipes that were labeled both JM Transite pipe as well as pipe that read Johns Manville Transite pipe.
So the issue of these being subsoil products and not permitted by the building codes in these particular buildings would be a question of fact that should survive summary judgment?
Absolutely. It's a question of fact based upon what may or may not have been the code, whether or not that code was followed versus the specific firsthand identification by Mr. Arana in this matter. And again, with respect to the issue of whether it was Johns Manville pipe or JM pipe, as Mr. Armstrong specifically testified, we're not talking about a small quantity of John Manville pipe that was then distributed by JMM. We're talking about what he described as in the tens of thousands of pipe which were loaded onto trucks for shipment after 1983 when this entity took over.
Right, but I mean, except that your client actually said he saw them where he was using, that would be 100% speculation that it came into this person's, but your client testified, that's what I saw, those are the pipes. Could, at trial, the defendant can absolutely as my colleague pointed out. How could that be? These were basement pipes. They had to be in ground. There was no way you could use them in that way, but.
Absolutely, that's a defense that this defendant can raise at the trial.
Okay.
If there are other issues that the court was specifically interested in, otherwise, I rest on the papers.
Any questions? Thank you.
Your Honors, I only have a minute, so I'd like to just emphasize that all of the documents that are used against JMM in any kind of litigation have always been the same. In 2019, Justice Mendez looked at all of our documents and found that there are unrefuted documents in our historical documents that show that we attempted to have different methods of warnings. And so we're here today on both motions because of Severe's punitive damages decision, and that is a 1980 document that Mr. Kronk was testifying about in every fifth pipe. That's also still not the standard. The standard is not, you put some warnings on bulk products, and I still think that standard on putting some warnings on some bulk products still shows that JMM had a method and different varieties of methods of putting out warnings, and that's uncontested. Whether it's the industry standards, our installation book, nothing has been refuted besides the warnings on the pipes. Thank you.
Thank you very much. And our last argument of the day is Pinpoint Multi-Strategy versus Volta India.
May it please the court. My name is Adam Finkel of Saberwall and Finkel LLC for the Appellant Bank of Baroda, New York branch. We respectfully request that this honorable court reverse the turnover order because the trial court erred by, one, relying exclusively upon a bankruptcy schedule.
Counsel, why was it improper to rely on the bankruptcy schedule since it was the company itself which created the bankruptcy schedule and relied on it to support its claim that the bankruptcy plan was reasonable? Why then shouldn't the court rely on it?
That's not my company that submitted the bankruptcy schedule.
Right, but it was one of the Volta
But it was Volta India. There are a number of reasons.
It was one of the Volta companies that
There
submitted that
are a
plan.
number of reasons.
Why wouldn't that be the best evidence?
Well, it's not the best evidence because the way it was used was to present a net asset valuation, which is not an appropriate metric for valuing a company that's a closely held corporation.
Well, first of all, they
That's a
did
going
use
concern.
it. You're saying it's improper, but they used it. But let's say that's true. Did your client ever produce, in opposition to the petition, a different valuation, a market
They
valuation?
deprived us of the opportunity because the bankruptcy schedule was submitted for the first time on reply, which
But
was 2
wasn't it
days.
submitted on reply because you, for the first time in opposition, raised the argument that the valuation, that there was a valuation issue? Once you raised the issue in your opposition, that there was an issue as to valuation and whether it was any excess, didn't you have a responsibility to come forward with your own evidence to support your claim as to what the valuation was?
I don't see it that way, Your Honor. What we raised in our opposition papers was that the $19,375,000 valuation that they put forth in their petition and their order to show cause was 8 years old, outdated, and totally irrelevant because the financial state of the company had changed drastically over an 8-year period. In response, instead of defending their $19 million valuation, they abandoned it and they came up with a brand new valuation based on a brand new document that was never before seen, which increased their claim effectively by 55%. They were seeking the turnover of shares from my client, and the number of shares that they were seeking to turn over increased in the reply
Well,
paper
so
by
let me,
55%.
well, let's unpack that. You in your opposition say that's not a good valuation, correct?
There were multiple oppositions to that that included Rolta India as well as my
Okay,
my
let's just talk about your client. Your client says
Yes.
not a good valuation because it's old, correct?
It is not an accurate valuation of the company, correct?
Because it's old.
Yeah, and the
Okay,
financial
so the court
status
could have
is
said, no, I don't find that to be particularly, you put in one affidavit from your, someone in your company who said, not a good valuation because it's old, and the value, the share value has changed. One, there's no evidence of that other than the affidavit that you put in opinion about that statement. And so the court was free to say, gee, I don't really think your client has, and there's no share, this is not traded.
The company was in
So,
bankruptcy, I believe, at the time.
At the
So
time.
there was evidence of that.
Except then, oh, look, when we look at what the company itself says it's worth in bankruptcy,
Well, I mean,
it's clearly not what your client thought it was worth. And you didn't put in anything that said what your client thought it was worth, just that you didn't think it was worth what they represented when they took out the money, correct?
That may be true.
It's all true, right?
That may be true, Your Honor, but the bigger issue is that they relied upon a net asset valuation, and the market value of the company, as stated in the bankruptcy schedule itself, is substantially lower.
But let me
than
just
that
ask you this, there are other courts that have relied on asset valuations.
In
Can we
certain
agree on that?
circumstances,
Yeah,
that
okay.
may be true,
So,
but not in this circumstance.
Why is it improper as a matter of law? And if that was true, why didn't you put in any evidence of how the valuation should have been done?
We did. We had an unrecorded oral argument. We had 2 days to respond to their new net asset valuation.
You're not allowed to
And
put
we
things
still
in.
stated,
Was my early question, why didn't you put it in when you first argued there was no excess collateral? That would be your best argument to put
they
forward.
weren't relying on a net asset valuation initially. They were relying upon a valuation that was set forth in a pledge agreement 8 years before.
Right, so
They
then
didn't
you come
rely
back
upon that
and say-
methodology.
You come back and say, that's the wrong methodology, that's incorrect, this is my methodology, but you didn't do that.
No, we didn't do that, Your Honor. But at oral argument, we did contest the net asset valuation that was used. And in our motion to renew, we set forth many cases which say that when you're dealing with a closely held corporation that's a going concern, you cannot just rely on net asset valuation. You have to look at market value, period. They put forth a case in response, one case, the Owen case, and in that case, they tried to assert that the Owen case said that you can rely upon book value. But that's not what it says. What the Owen case says is that this was an extraordinary set of circumstances, it was a peculiar matter, and we are relying upon book value only because there is no discernible difference between the book value and the market value of this company, which is a closely held corporation that is a going concern. That is the only case that they put forth in opposition to our cases which say you can't use net asset valuation alone. So bigger than the issue of whether or not it is, a direct response to what we said in our opposition or not, the net asset valuation is improper as a matter of law, and they have not provided even a scintilla of case law to suggest otherwise.
Thank you, you have rebuttal time.
May it please the court. Jeff Derrick of Cobre & Kim on behalf of the petitioner's respondents. This court should affirm the IAS Court's CPLR 5225B turnover order because it properly valued the shares.
All right, so what do you say to counsel's argument that as a matter of law, you may not use the net asset value?
Well, Your Honor, as we stated in our brief, this is not a publicly traded company that is privately held. And the reason that we submitted the bankruptcy schedules in the reply brief was in direct response to Rolta India's argument in opposition that the valuation was stale. And they had just days before submitted an assets and liabilities picture, which in vivid detail described the various assets and liabilities of the company. There hadn't been any market valuation of the company because it was held still under the control of Rolta India, which Justice Maisley had ordered Rolta India to turn over the company to our clients. Rolta India, to this day, refuses to do so. So our clients were not able to undertake, sort of a market valuation.
Well, let me ask you something. What happens if you get this asset, and it turns out that what the judge left with the bank isn't enough to cover its secured loan. How is that the result?
Are you saying, Your Honor, if the amount of shares turned over to our clients now leaves the bank under collateralized?
Undersecured, yeah.
That's an interesting question, Your Honor. I think that
Well, isn't that what they're worried about? That they're not coming here on this appeal because they want to spend the money. They're worried that now they're under collateralized.
well, Your Honor, there's no evidence in the record. As I think the questions indicate, this is a clear case of waiver. At various points, Bank of Baroda could have submitted an alternative valuation. They did not oppose the petition itself. They submitted an affidavit. They did not move for a reply when we submitted the bankruptcy schedules with our reply brief. There were 3 weeks between the oral argument and Justice Engoron's decision finding in our favor on the petition. And when they moved for renewal and re-argument, the supposed new evidence that they pointed to was our own briefing in the bankruptcy court. So any of those, at any of those times, they could have submitted a valuation that would have substantiated their argument that they would be under collateralized. The only evidence that was before the IAS court shows that they will in fact be over collateralized to the tune of about $12 million.
The two valuations, the one in the bankruptcy court and the original one on the note, they both show they're over collateralized.
That's correct, Your Honor.
Okay.
How do you respond to your friend's point that you essentially impermissibly changed the value methodology on which you were relying, that with your petition, you submitted a certain packet, a certain submission. They responded by saying that information is outdated and therefore presumably isn't credible. And then in response, in reply, instead of responding to that particular argument, you now sort of shift gears and rely on a new value methodology.
Sure. Yes, Your Honor. So the share pledge agreement is a 2013 agreement where Bank of Baroda and Rolta India both agreed that the pledged shares at issue here were roughly worth about $19 million. Rolta India in its opposition says that's a stale number. So to bring the number current, we pointed to an asset and liabilities picture that Rolta International had submitted to a bankruptcy court just days prior to say here, if the court has any concerns about the staleness of the valuation of the share pledge agreement, here is a much more recent asset and liabilities picture for the entities whose shares are at issue in the litigation. We were not trying to shift our position in front of the IAS court. We were simply trying to address Bank of Baroda and Rolta India's argument that it was a stale valuation. We think it was appropriate to do so with that evidence on reply.
Let me just ask you, if the court had used the original 2013 valuation, would you still get the same number of shares?
I think if, Your Honor, I think this number of shares would be different because the number of shares that were ordered turned over to us was calculated based on the amount due to Bank of Baroda outstanding on the loan facility. So I think it's roughly $7 million that Bank of Baroda is due. If the shares are worth 19, that would be we would be owed a different number of shares than, for example, as the IAS court found, the shares were worth roughly 30. So I think it would just reduce the number of shares that were. It changes the amount the bank is over collateralized, depending on the valuation. So the number of shares would change as well, I believe.
Thank you very much.
Thank you, Your Honors.
I just have a couple of quick points, just regarding the number of shares. It certainly would, if the court relied upon 19 million as the valuation for the pledged shares, the number of shares would be reduced by 55% of what the court ordered in the turnover order. It's 55% difference. So it's a major change in position. It's a complete abandonment of their initial methodology and valuation, and it was submitted for the first time in the reply. Just regarding the motion to renew, the documents.
Did you ask the court to address that on the initial motion?
On the initial motion?
Yeah. Did you say, look, we got this new valuation in, can we put in a certify?
Well, the problem is.
I just want to know if you did or didn't. I'm not.
What we did was, at the oral argument, we contested the methodology. We said that the net asset valuation is not appropriate.
Asking, but I don't have,
and it
we
does
don't have
in,
a record of that. So this
I know
is what
that,
I'm
but that's
asking you. I'm asking you whether you asked.
We did.
You did. You asked
not
for
in
a
writing,
reply?
not on the record until the motion to renew, because it wasn't an issue until the reply and the 2 days later, we had the oral argument, which was unrecorded. So I didn't have an opportunity to put it in papers.
Thank you very much.
Until the motion to renew. The only other issue that I had was.
Your time's up now.
I'm
Thank
sorry.
you.
All right.
You too. Someone left a mask up here.
That's a go. Take care. See you. Nice to see you in person. See your name on papers. What's going on?
Not much.
What? Is that what it is?
Nope.